Good afternoon and welcome. This is a regular meeting of the Sunshine Ordinance Task Force called for Tuesday, May 24, 2011 at 4 p.m. and beginning at 4:06 p.m. Roll call, please.
Yes, Mr. Chair. Member Snyder? Here. Snyder present. Member Nee?
Here.
Nee present. Member Cawthon? Aye. Cawthon present. Member Manny? Manny absent. Member Washburn? Washburn absent. Member Caneba? Caneba absent. Member Costa?
Aye.
Costa present. Member Wolf?
Here.
Wolf present. Member Chan? Chan present. Member Johnson? Johnson absent. Member West? West absent. Mr. Chair, we have a quorum.
Okay, thank you. First item then has to be which of these absent members we excused. I have Member Knebber out for work reasons. Member Johnson will be late due to work and family reasons. Member Washburn is out for medical reasons. Members Chan and Cawthon will have to step away a little later, briefly, for various valid reasons. So, without any objection then, unless there is objection, we can declare all of these absences and hiatus to be excused without objection. And Mr. Rustam, have you heard from Member Mane or Member West?
No, Mr. Chair.
Okay. Then pending any further word from them, I mean, I think it's reasonable to assume work-related absences or tardiness, but if they haven't contacted us, which is their responsibility, then I think it's appropriate to mark them absent. Members? Okay. Changes to the agenda? The chair will bring in two changes. Item numbers 20 and 27. These are minutes for which no attachments have come in the information packet. So, without objection, those items, number 20 and 27, are continued until our next regular meeting, which would be June 28th.
It's 20 through 27?
No, 20 and 27.
Okay.
Item numbers 20 and 27. Any further changes to the agenda? Seeing none, Mr. Clerk, could you call the first item, please?
Yes, Mr. Chair. The first item is determination of jurisdiction on complaint filed by Deborah Benedict against the Nonprofit Tide Center for allegedly violating Admin Code Chapter 12L.
So moved.
Has jurisdiction been contested?
No, Mr. Chair.
Okay.
Attorney.
Moved and second, Member Costa.
Well, as was the case last time, last time this came up, I recused myself, or I moved to recuse myself and was recused of this case.
Okay.
I feel probably it makes sense for me to do the same. I wrote Chris saying I was going to do so.
Okay, if you do recuse, that'll mean for the moment we have no quorum, but that's the way the ball bounces sometimes. Is there a motion to recuse Member Costa?
I move that we recuse Member Costa.
Excuse me. Members, could we please speak into the microphones?
I move to recuse Member Costa.
Is there a second?
I'll second it.
Moved and seconded. Discussion. Is there a motion on the recusal? Seeing none. The Member Costa's vote should be recorded on this also, I believe.
Yes.
On the roll call, please.
Yes, Mr. Chair. On recusal, Member Snyder?
Aye.
Snyder, aye. Member Cawthon?
Aye.
Cawthon, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan?
Aye.
Chan, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, the 6 ayes, the motion passes.
Okay. In that case,
Mr. Chair, I'm wondering, the last time I believe Member Cawthon also recused herself. Was it on this item? No, it was another. Okay. I'm sorry, because I remember both.
Okay, don't leave because we're going to have to continue this item without a quorum. Is is either party in interest present? Okay, and is Ms. Benedict here? Okay. The only thing I can say is if we get enough people for a quorum later on, then we may bring this back. If Ms. Benedict doesn't appear, then the matter will be tabled. That's the best information I can give you at this time, and I apologize for any inconvenience this is going to cause. Ma'am, please approach the microphone.
Can you please explain what you mean if Ms. Benedict does not appear, the matter will be tabled? What exactly does that mean?
Well, she is the complainant, and if she does not appear to before us to give her side, then the matter is tabled, which means it could come up at our next meeting, which would be June 28th, or if she doesn't appear then the matter would be taken off the table entirely, and she would have to refile the complaint in order for it to be heard.
Okay, thank you.
Okay. We apologize for any inconvenience this causes you, and we thank you for your patience. We thank you for being here. That takes us to item number 3. Could you please call item number 3?
Item number 3 is determination of jurisdiction on complaint filed by Charles Spitz against Supervisor Jane Kim for allegedly failing to respond to an immediate disclosure request for public records related to the Shelter Monitoring Committee.
Okay. Is there a motion to find jurisdiction?
So moved.
Has jurisdiction been contested?
No, Mr. Chair.
Okay. Moved and seconded. Is there any public comment on the jurisdiction question of this item? Seeing none, roll call, please.
On jurisdiction, Member Snyder?
Aye.
Snyder, Member Cawthon? Aye. Cawthon, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan?
Aye.
Chan, aye. Member Nee?
Aye.
Nee, aye. Member... We have 6 ayes, Mr. Chair. The motion passes.
Okay, that takes us to substance. Is Mr. Pitts present? Is the respondent present? Okay. Without Mr. Pitts to present his complaint, my inclination is to table this. Task force? Without objection? Okay, this is tabled. Okay, sir, we want to thank you for attending. This matter is being tabled, which means it will go on the agenda for our next regular meeting on June 28th. If Mr. Pitts does not appear at that time, then it's taken off the table, and if he wishes to have it heard, he would have to refile. So thank you for being here, sir. Is there public comment on this item? Is there public comment on this item? Thank you, sir. You have 3 minutes.
Thomas Piccirillo. There are very few complainants in the room. Perhaps there's confusion as your starting time. Last week you met. It was a special meeting, but it was at 5 o'clock. So maybe a lot of people thought that tonight's meeting was also at 5 o'clock. So rather than table these early cases, perhaps you could continue them and then maybe hear them after 5 o'clock if the complainants were under the impression that this meeting was to start at 5 o'clock, like last week's, rather than 4 o'clock. Thank you.
Thank you. Is there further public comment on this item?
Members of the task force, Ray Hartz, Director, San Francisco Open Government, and I would have to agree with Mr. Piccirillo. There have been numerous agenda errors in the past several months. The most frequent one being that the meeting time changes 4 o'clock, 5 o'clock in some cases, and then even in the cases where it changes from 4 to 5, the public comment section still lists in the agenda as being held at 5 o'clock, which would mean that would be the very first thing to be done, and it isn't. It's held an hour later at 6 o'clock. So I think that, number one, getting the agendas accurate so that they're actually reflecting what is going to occur, in particular the public comment section, would be appropriate. But I do think that having the meetings at 4 o'clock one time and 5 o'clock next time and going back and forth really does place a lot of people in an awkward position as to knowing when they're supposed to be here. If you come to meetings, 5 or 6 times in a row and it starts at 5 o'clock, you start to add, it's in your mind that 5 o'clock is when the start time is. And, I don't think it's very good for your business in carrying out these to be continuing them. And it also puts the respondents or other people in a position of having to come back in some cases where the other person might simply show up. So I would agree continuing this till later in the meeting to ensure that all the persons that are listed here on the agenda have an opportunity to come, and it isn't a question of them just getting the wrong time. I think it would be not only fair to all the parties, but I think it would be a little more conducive to the conduct of the business before this task force.
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. Task force? Member Wolf?
I would just say that laying it on the table for this particular meeting is not postponing it indefinitely, or it doesn't take anything away from it being brought back to be discussed later on in the meeting. If we find that towards the end of the meeting, if the complainant doesn't show, then we can postpone it to the next meeting, or actually continue it.
Member Coffin?
I was just going to say the same thing, that Robert's Rules of Order says you can take something off, the chair can take something off the table at any time.
Anybody can.
In other words, if they show up later, we can bring it back.
Yes.
Okay.
Just means it stays within this agenda for today.
Okay.
That's what it means.
And if not today, then June 28th.
Right.
Okay. I believe that takes us to item 5. Mr. Clerk, could you read the item, please?
Item number 5 is determination of jurisdiction on complaint filed by Suzanne Dumont against the Recreation and Parks Department for allegedly failing to respond to an immediate disclosure request.
Okay. Is there a motion to find jurisdiction?
So moved.
Is there a second? Moved and seconded. Member Cawthon seconded. Is there discussion? Is there public comment on the jurisdiction question of this item? Seeing none, public comment is closed. Roll call, please.
On jurisdiction, Member Snyder?
Aye.
Snyder, aye. Member Cawthon?
Aye.
Cawthon, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan?
Aye.
Chan, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 6 ayes. The motion passes.
Okay, that takes us to the substance of the matter. Is Ms. Dumont present? Is the respondent present? Okay, neither party is present. This matter is tabled. Mr. Clerk, could you call item 7, please?
Yes, Mr. Chair. Item number 7 is determination of jurisdiction on complaint.
Oh. Is there public comment on item? I stand corrected. Is there public comment on item number 6? This was Dumont against Recreation and Park Department. Seeing none, public comment is closed. That takes us to item 7. Apologies for my lapse in memory. Item 7, please.
Item 7 is determination of jurisdiction on complaint filed by Charles Spitz against Supervisor Mark Farrell for allegedly failing to timely and honestly respond to an immediate disclosure request for public records related to the Shelter Monitoring Committee applications.
Is there a motion to find jurisdiction?
So moved.
Second.
Moved and seconded. Discussion. Is there public comment on the jurisdiction question of this item? Seeing none, public comment is closed. Roll call, please.
On jurisdiction, Member Snyder?
Aye.
Snyder, aye. Member Cawthon?
Aye.
Cawthon, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan?
Aye.
Chan, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 6 ayes. The motion passes.
Okay. That takes us to substance. Mr. Pitts is still not yet in the room. Is the respondent present? Okay. Ma'am, because the complainant is not here, he cannot present his case. We're going to table this matter until either later in the meeting when he shows or until June 28th. And we're sorry for any inconvenience this will cause.
Okay, thank you.
Thank you.
And for the record, it's Catherine Stephanie for Supervisor Mark Farrell's office.
Okay. Thank you very much.
Just a point of order, Mr. Chair. I stand corrected on Robert's rules. We should be using postpone and not table. Table is only supposed to be used for interrupting when there is an emergency item. So we just postpone it until these people show up. We just do that globally. Just to be correct. Thank you, Mr. Piccirillo.
Is there public comment on item number 8? Seeing none, public comment is closed. I note that Ms. Benedict is here. She is the complainant in item numbers 1 and 2. However, because of a recusal, we again have to continue this matter until at least one other member appears. Otherwise, we are without a quorum. So apologize for any inconvenience this causes to either side.
Mr. Chair?
Member Wolf.
I'm wondering, since we might have 1 or 2 members that are coming late that notated, I'm wondering if we might postpone the item to later in the meeting until they show up.
Well, we do have a whole number of items to get through here, and there are some complainants and respondents here.
I understand that.
So I would say we move through the agenda. We also have a number of a whole raft full of minutes to look at. We do have another member coming in now, so we can take item number 2. Item number 2 is Deborah Benedict against the Tides Center. This is an alleged violation of Chapter 12L.
Sure, she's going to recuse herself as well.
Wait a minute.
Oh, that's right. She was the one that recused herself.
Okay. Well, we stand corrected then. We have 2 members recused. That still leaves us without a quorum, so we still have to continue this until we get at least one other member.
Member Mene. I know. Funded. Thinking they had funded for her employer.
Okay. I believe there was no public comment on item number 8, and that takes us to item number 9. Mr. Clerk, could you read item number 9?
Yes, Mr. Chair. Item number 9 is determination of jurisdiction on complaint filed by Charles Spitz against Supervisor Sean Ellsburn for allegedly failing to timely respond to an immediate disclosure request for public records related to Shelter Monitoring Committee applications.
Is there a motion to find jurisdiction?
I move we find jurisdiction.
Second.
Moved and seconded. Discussion. Is there public comment on the jurisdiction question of this item? Seeing none, public comment is closed. Roll call, please.
On jurisdiction, Member Snyder?
Aye.
Snyder, aye. Member Cawthon?
Aye.
Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan?
Aye.
Chan, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 7 ayes.
Okay. Is Mr. Pitts in the room? Okay. This item is postponed until he appears or until If he does not appear today, then it's put off till the June 28th meeting. Is there public comment on this item? Seeing none, public comment is closed.
Yeah.
I register that the respondent is here. My name is Alex Volberding from Supervisor Sean Ellsburn's office.
Okay. Thank you very much, sir. Mr. Clerk, could you read item 11, please?
Mr. Chair, I have someone from the clerk's office read the item because I need to make a presentation on behalf of the clerk of the board.
Okay, I can read it. Item 11 is a determination of jurisdiction on complaint filed by Thomas Piccarello against the clerk of the Board of Supervisors for allegedly not providing timely and accurate minutes regarding various Sunshine Task Force committees. Is there a motion to find jurisdiction in this?
I move we find jurisdiction.
Is there a second?
Second.
Moved and seconded. Discussion. Is there public comment on the jurisdiction question of this item? Seeing none, roll call, please.
On the motion to find jurisdiction, Member Snyder.
Aye.
Snyder, aye. Member Cawthon.
Aye.
Cawthon, aye. Member Manna.
Aye.
Manna, aye. Member Washburn.
She's excused.
Excused. Member Canover. Excused. Member Costa.
Aye.
Costa, aye. Member Wolf.
Aye.
Wolf, aye. Member Chan.
Aye.
Chan, aye. Member Johnson.
Excused.
Excused. Member West. Absent. Member Nee.
Aye.
Aye. Mr. Chair, there are
7
ayes. Thank you.
Thank you. That takes us to the substance of the complaint. Mr. Piccarello, please approach. Thank you for coming, sir. You have 5 minutes.
Good evening, Thomas Piccarello. As you can see on your agenda item, my complaint was against the clerk of the Board of Supervisors for not providing timely and/or accurate minutes. Mr. Schneider and Mr. Treat can appreciate this. When law students first start out in law school, in their first year of torts class, they learn a Latin expression, res ipsa loquitur. The translation for that is the thing speaks for itself. And if you look at your agenda this month, you will see.
Oh, it's outside.
We on?
Yeah, it's just music that they're testing from outside.
Oh, okay. If the thing does speak for itself. If you look at the minutes on your agenda this month, the minutes that haven't been approved go back to January 2004. It's pretty obvious that your minute keeping are both not timely and aren't accurate. And they're not accurate in the sense that they're not descriptive enough to describe to the public and to the task force members what has transpired. So I would like a finding that the minutes are not in compliance with the Sunshine Ordinance. Thank you.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Thank you. You have 5 minutes.
Good evening, Chairman, members of the task force. My name is Chris Rustum with the clerk's office. Members, the clerk's office has always provided timely and accurate minutes as required by section 67.16 of the Sunshine Ordinance. Specifically, the minutes of all Sunshine Ordinance Task Force and all of its subcommittee meetings show the time the meeting was called to order, task force members who were present or absent, and agenda changes, if any. And these are all the requirements that are mentioned in section 67.16. The minutes also show if a member was recused from a particular item, the reason why, and how members voted on the recusal. The minutes also identify the complainant and the respondent, the maker and sponsor of a motion if one is presented, and how members voted. These are also requirements that are in 67.16. The minutes also include, whenever possible, the name of individuals who provide public comment and a brief description of what was conveyed. The minutes also reflect whether members of the public spoke on various topics. And finally, the minutes indicate the time the meeting ended and the reason why, if any, other than no more business. Mr. Chair and members of the task force, the clerk's office is committed to providing accurate and timely information to the public, and with all the new deadlines which have been adhered to, the public is much more informed of the actions of the Sunshine Task Force. We now have, the Sunshine requires that the draft minutes be ready 10 days after the meeting. It is now posted on the website 48 hours after the meeting. Also, the audio recordings are also posted 48 hours after the meeting. And if you see the handout I just gave you, there's also a timestamp on it, so whoever wants to listen to the meeting, if a member misses a meeting and wants to follow up on it, I have a timestamp on it, and you can go to that particular spot on the recording and hear what was discussed and said. Thank you very much.
Thank you. Is there anybody to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Member Cawthon.
You know, we have the same problem with the Library Citizens Advisory Committee, but I just told everybody we should do what the ordinance says. And the ordinance does have requirements. We certainly can make the minutes as discursive as we want or as the minutes writer has time for, but I do think as long as we follow what the Sunshine Ordinance prescribes, we are within the law.
Member Snyder.
Mr. Piccarello, could I ask you a couple questions?
Mr. Piccarello, please approach.
Sure.
So in your complaint, you say you say that the minutes are not accurate or timely. Can you be could you be more specific? Perhaps referring to a specific set of minutes.
Yeah, sure. Yeah. Well, in many instances, I will make public comments at these proceedings. And what the minutes show is that I spoke on various topics. I think the Sunshine Ordinance requires more than that, at least a brief description as to the topics that I gave public comment on, and also my position. Understand that the minutes are for public consumption, so the public that cannot attend your task force meetings are at least aware of what's going on at the task force meetings. And they're also, quite frankly, for the task force members, because you certainly don't have memories of what transpired 3 months ago. And if you look at your minutes, these minutes going back 5 months. So it's there's a reason that the Sunshine Ordinance had a minute record-keeping provision in the Sunshine Ordinance, because it provides the public that are unable to attend the meetings what's going on at this policy body. And again, it also advises the task force members. It refreshes their recollection as to the issues that were discussed. So when I say timely, the task force should remember that many of the minutes have been denied approval because they don't accurately reflect what has transpired in previous meetings. So I'm not the only one with this opinion. I think the task force, by not approving previous minutes of your task force meetings, is a recognition that the standard is not up to what's mandated by the Sunshine Ordinance.
Are there any instances where you allege that the draft minutes were not available within 10 days? That's the requirement of 6716, is that the draft minutes have to be available.
Fair question. I can't recall the draft minutes not being available in 10 days. But that's not the substance of my complaint. It's the final version of the minutes. That's the problem with the task force minutes. Your draft minutes can be timely in 10 days, but if they don't reflect what the public has discussed or what the task force members have discussed, you are not helping the public at all in keeping apprised as to what's going on with sunshine in the city.
Is there, in your complaint, are you relying on any section other than 67.16? And, I mean, you don't necessarily have to be relying on that one, but are there other sections that of the Sunshine Ordinance that you're pointing to?
No, I'm not.
Okay, thank you.
Member Wolf?
Mr. Piccirillo, so in 6716 it states that a list of those members of the public who, I'm taking from the middle of the sentence, a list of those members of the public who spoke on each matter if the speakers identify themselves, and then a brief summary of each person's statement during the public comment period for each agenda item. Can you provide some examples of where you feel if the brief summary falls short?
Well, again, I can specifically remember some of the minutes that were proposed for approval that had me speaking on, and the minutes reflected saying several subjects. That's not a summary of what I said. So if I was to chastise the task force for not having a quorum, if the minutes reflect that I spoke on several subjects, that doesn't tell the public that the task force members are not showing up pursuant to their promise when they got appointed by the supervisors. And it's more than one occasion. It's not just that particular item. The minutes are not reflecting what is happening, in my opinion, at the task force meetings, whether it's special meetings or committee meetings or the full task force. The minutes are not accurately telling the public what is going on at the Sunshine Task Force.
Thank you.
I'm sorry, one other
Member
question.
Wolf?
Besides the public comment area of the minutes, is there any other area that you feel is deficient that is not covered under 6716?
Well, I think the minutes don't reflect what the members address either. It's not just the public comment that's deficient. I think the minutes do not also accurately reflect the discussion by the task force members. And again, that's helpful to the public, for the public to know what the positions are of the task force members. And when they render a decision, they'll get a better understanding as to why.
And last question: if the law, the ordinance, allows for there to be action minutes, only whether there was a yes or no vote on an item, and then the public comment section, if that is what the law minimally provides, what would your response be then?
Would I be in? I'm not sure I understand the question.
How would you expect us to proceed if the Sunshine Ordinance allowed for action-only minutes?
Well, the Sunshine Ordinance doesn't make the distinction, I don't believe, in its provision regarding minutes as actionable versus non-actionable. It just discusses minutes. So, you're raising an issue that doesn't exist. Finally, let me say this, though, about this item on your agenda. I made an IDR to the Sunshine Task Force staff requesting any correspondence between task force members and the clerk regarding problems in record keeping, regarding minutes. The response by Mr. Rustin was that first he couldn't respond in one day because the response was voluminous in materials, and then he provided me nothing at all regarding communications between the task force members and the clerk of the board. So either someone's hiding the ball on communications regarding the problems you're having with record keeping, or I don't think you're living up to your responsibility of advising the clerk of the board problems that you're having with minute keeping.
Thank you.
Member Cawthon.
I know I like to quote Robert's Rules of Order. And as I say, we've had this problem at the library CAC as well, and there are people who come to our meetings and want us to really state what the members said. And there are two problems. One, the minutes taker is not as experienced as Mr. Rustum, so it's really hard to, we usually take the minutes ourselves. But the second thing is, what do you include and what do you leave out? I think that's the reason there's a recording, so that if people want to know what was said, they can listen to the recording. But what Robert's Rules of Order says, that minutes reflect what a group does and not what it says. Having said that, and we certainly are within our right to suggest that minutes be more discursive and that the minutes taker provides some idea of what members said and certainly be more lengthy regarding public comment. This is all within our ability to do. It's just a question whether what we want to do for good practice and efficient meetings. So other than public comment and the fact that you don't think that our minutes reflect what people say, are there any other problems that you have?
Well, as previously expressed, you shouldn't be discussing minutes that occurred 4 months ago. Maybe you're better than me, but I can't remember what I did 4 months ago, what I said 4 months ago. So you're really playing a charade when you have minutes in front of you that were discussed in January or February of this year. Perhaps your memory is better than mine, but I question whether you can remember what you said January 15th regarding an issue on your agenda. So it's not only that the minutes do not reflect what is discussed, but it's the length of time that it takes for the clerk to produce minutes that have been discussed. And again, remember, the minutes are for the benefit of the public, not for the clerk of the board, not for this task force. The minutes are to educate the public what's going on in public policy bodies. This is a policy body. Public has the right to know what's going on. If you can't get these proceedings televised, which is an alternative to your problem in getting minutes taken accurately and timely, if you can't get these proceedings televised, then you have to get your minutes up in compliance with the Sunshine Ordinance and the Brown Act.
Member Wolf?
I would.
And Member Chan.
I would just say to that, they're recorded. There's audio recording. So whether there is video recording or audio recording, there is a record of the entire meeting. So I think that point's moot.
Member Chan.
Yeah, I was about to say the same thing. There's a record. You could just, request audio taping of it and then see the minute and compare.
Yeah, well, can I respond to that?
No.
No.
Member Costa.
The further thing is, I know this happens at the Library Commission all the time.
Excuse me, I believe I called on Member Costa.
Okay.
Member Costa, then Member Cawthon.
So just sort of leafing through some of the special meeting draft minutes that are up for approval a little bit later in the meeting, and I did actually find an instance of, I think, what Mr. Piccarello is talking about. It's the January 25th meeting minutes. They're on page 156. So they start on page 156 of our packet. The item is on page 159. But under the public comment, it says Thomas Piccarello and Jason Grant Garza spoke on various issues. And I do tend to agree with Mr. Piccarello that that to me is not, might not be completely sufficient in acting as a brief summary of each person's statement, lumping two different public comments into one sort of description about various topics. It seems a bit overly vague. And I do think that, what various members have said about there being audio recordings is valid, and that the description of each public comment needn't be overly verbose either, but perhaps if there are independent public comments on various issues, each one of those issues can be, and should be listed and given at least some sort of description so that someone who wasn't at the meeting knows whether or not they should be going to look or listen to that audio recording.
Member Coffin.
Yeah, I just wanted to reiterate what I said about the Library Commission. There are a couple of people who come to the Library Commission and do object to the way their public comment was stated, and they ask that it be changed to reflect the scope and the actual facts. Sometimes the Commission does it. Most of the time it doesn't. But there's nothing to stop a member of the public to stand up and say, well, my comment does not reflect what I said, and this is what I said, because we are required to provide a brief summary of what the person says, and also a record of whether or not they were for or against whatever the item is.
Okay, at this time, the respondent and then the complainant will each have 3 minutes to make any concluding or rebutting remarks. Mr. Rustum.
Thank you, Mr. Chair. Members, I do not have anything to say.
Thank you, sir.
Thank you.
Mr. Piccirillo, 3 minutes.
Just briefly, you are sending the clerk the wrong message if you don't sustain this complaint. Thank you.
Thank you. Matters back with the task force. Is there a motion? Member Wolf?
I move to find a violation of 6716.
Is there a second?
Second.
Moved and seconded. Discussion. Member Wolf, Member Snyder.
The reason why I made the motion is because I do find myself that this brief summary is to be fairly incomplete and, if not impotent, at many times. I cannot make heads or tails of what happened during, if no actual discussion of what happened in the meeting is required except for the vote itself, and I don't have an accurate description of what the public might have said, then it makes it equally difficult for me to be able to know what happened in a previous meeting, especially if I wasn't there. Now, granted, I could go back and listen to the audio recording, but by the same token, if I have to sit through 7 hours of audio to be able to review the entire minutes of a meeting in and out of discussion that is not may or not be pertinent to getting to the final to get to a motion and a final vote, then I find it to be somewhat incomplete. If there was a person who required Braille, for it, and let's say for it wouldn't be for audio recording. If they were, I'll take that back. I'll have to rethink that example, but that's what I have to say about it.
Member Snyder.
So would the motion for the violation be based on the failure to comply with the brief summary provision?
Correct.
So in that case, I think it would be useful, if not necessary, to specify a couple of instances where the brief summary was not, where that provision was not met. In other words, I think it's difficult for the task force to find a violation of sort of in the abstract. Like we should say where the violation is. And two reasons for that. One, because I think it's important to point out where factually there was a violation rather than saying in the abstract. And second, it would aid the clerk in complying in the future. I think it's tough to make the argument that, unfortunately, brief summary is very vague, and I think it's hard to make. I mean, we can really only hold the clerk to the standard of the language itself, and we can disagree as a policy matter that it's not, or state as a policy matter that it's not clear or specific enough. But is it fair to hold the clerk of the board in violation of not providing a brief summary? I mean, it's a very vague statement. Brief summary, that is.
Member Wolf.
I would just say in response to that, I mean, I can open up any number of the minutes that are provided in our packet today, and anybody can read that there would be a deficient summary of what somebody says. I mean, I can give you one right now. We just got handed out Tuesday, May 18th. It's a draft minutes for a special meeting on page 8. This is the Clark case. It says that David Pilpel said Section 6724C6 was written for a specific reason that arose years ago. What was the specific reason? I know he explained it, but that means I have to go back to a audio recording that is not time-coded for that particular item. So that means I have to sit through, and if you've ever tried to follow something on an audio recording to try and nail down exactly where something was said, it's very difficult. So without any kind of marker or time code that is attached to the audio recording so I know who said what where, it makes it impossible for me to know what the specific reason was that Mr. Popel had brought up. And I know that he did make some specific specificity as to what that reason was at that time.
Mr. Threet, and then Member Coffin.
Through the chair, to clarify the discussion, which appears to me to be directly on point as to what the issue is, the requirement of 67.16 as to the positions of the public speakers and the brief summary applies to the final minutes, not the draft minutes. So if there is some insufficiency in the draft minutes, there may be numerous insufficiencies in draft minutes, and presumably that is the reason why the draft minutes are first put out and comment is taken upon them, and the task force can change them. So that's just a minor clarification of the issue. It does sound to me like the consideration of the criteria is entirely appropriate under 67.16.
Thank you. Member Coffin.
Yeah, I just wanted to really reiterate what Mr. Threet said and also add that at one of our first secretary after Prop G passed simply refused to go into great detail in public comment. So we asked her just to provide, quote, a brief summary, which of course is hard to determine. But I think that the minutes that we have, I mean, you know, we have minutes of 3 committees. We are now having 2 meetings a month. It's a lot of work. And I think that the minutes within the framework of what we're supposed to do under 6716, they're very good. The problem is, I mean, public comment could be more discursive, and maybe now the secretary will make them so. But I think that if we do have a motion that there's been a violation, we should also note that other than the violation, the minutes do conform to the requirements of 6716. You know, I'd like to see the minutes out earlier myself, but I'm not quite sure what the reason is, whether or not because they're sent back for various reasons. I do know that Mr. Rustum said they're posted within 48 hours, so they are certainly within the public purview within the 10 days. The second thing is about videos. Yeah, unless they're unless they're number coded, it's hard to go exactly to where they are. But I mean, I've gone through an awful lot of videos, and if you know what the agenda is, you know the order of the agenda, then you can find your item. So these are my comments.
Member Schneider. I'm sorry, Member.
I don't think that we should come out with a huge violation. I think we should have a countervailing statement that in large part, the minutes conform to Section 6716.
Member Wolf.
You know, this is not, you know, this is specifically on the clerk of the board who provides us with staff to be able to do this, whether it's the person who's currently in the seat or any other person. This is the kind of the orders that came down from the clerk of the board as to where things, how the minutes are now written up compared to the way they used to be written up. I am not, I look at how many minutes we're behind. And the reason why we're behind is because we've sent them back for this particular reason. So I would just say, let's remind ourselves why we have not passed minutes, because we've returned them back because we found them to be incomplete in one or all parts. So I think at this point it's a message to the clerk that we are unsatisfied with the way they've changed the way the minutes have been done in the way that we are used to having them. If we're a quasi-judicial type of body, I don't think any court of law would allow minutes or a transcript to be distributed in this format.
Member Snyder, and then Member Coffin.
Well, so the section that we're reviewing, 6716, it lays out certain requirements for the draft minutes, and so the question before us is whether the draft minutes fit those requirements. And I will have a hard time supporting a motion that finds a violation for the brief summary, because I think for draft minutes, brief summary is a pretty vague and general term, and I think it's pretty easy to meet. I think Member Wolf's point about the task force sending these back to the clerk of the board is an excellent one. I also think that's a way to enforce to ensure that when the final minutes come out, they express more completely what the testimony at the meeting said. But I think for draft minutes, which is what is at issue under 6716, what we've seen and what I've heard in testimony, I think it's hard to justify a violation of the brief summary section.
Member Coffin.
I just wanted to point out that the Board of Supervisors final minutes are as brief as you can possibly come. You can barely tell what they were doing, but obviously they're considered to be legal by the clerk of the Board of Supervisors and the supervisors.
Member Johnson.
I came in the middle of this conversation, but no one's challenged it. Does not necessarily mean that they're considered legal. Has anybody ever challenged the Board of Supervisors minutes? Because they're in violation of 6716 if you perceive them that way.
I have some comments I'd like to make of my own. First of all, there's been people have held up the draft minutes of the task force meeting of Tuesday, May 18th as an example. Unfortunately, the minutes of May 18th are irrelevant to this complaint. This complaint says violations, where are we? Okay. The complaint is violations of the Sunshine Ordinance for failure to provide to the public timely and accurate minutes regarding the various Sunshine Task Force committees. Not the task force committees. Second, the task force has 3 and now 4 committees. None of those committees is specifically named in the complaint. Third, no specific examples of inadequate or erroneous minutes of a committee is provided in our packet. There is a lack of evidence here. Now, having said that, I will add that we are not unaware of that there are problems with the minutes. As a matter of fact, we have met at least once with the clerk of the board on the matter. We plan to meet again with the clerk of the board on the matter because, frankly, I'm not terribly thrilled with the draft minutes either. But in this matter, I'm going to, I don't feel that there is justification to vote for a violation, to find a violation. Member Johnson, Member Snyder.
I don't know if this was brought up before, but we rejected the minutes in committee.
Yes, it was.
So how do you attach, I mean, that happened, I think, before this was filed. How do you attach those? I mean, that would be some pretty relevant evidence that we don't think that they're following the rules.
Member Snyder.
I just wanted to correct something I said earlier. I said 6716 applies to draft minutes. What I meant to say is it applies to final minutes. My point was that if the standard for final minutes is a brief summary, then what we get under the draft minutes is, I think it's hard to find a violation of under the draft minutes, which we're looking at, of that brief summary qualification. So I misspoke. 6716 applies to final minutes, not draft minutes.
Member Wolf, Member Cawthon.
I would just say, I mean, I can read any number of the minutes from the committees right now that are in here. I mean, and speaking of the complainant himself, in a March 10th draft meeting minutes of Rules Committee, it just says that Thomas Piccarello spoke in favor. Doesn't say anything else. There's no summary of what he said. And the ordinance requires that both, whether the speakers supported or opposed the matter, and a brief summary of each person's statement should be notated. So I don't see how it's irrelevant.
Member Cawthon.
You know, I've been on the task force for 10 years, and we have had actually a complaint on this issue. I believe somebody brought a complaint that the Library Commission minutes weren't discursive enough in one particular instance, and we found that they did indeed provide a brief summary, although we agreed the term brief summary is certainly a bit evanescent. I have a question for Mr. Threet. Chair Need did point out that the complaint talks about committee minutes. It doesn't talk about special meetings and full task force minutes. So that, can we do a resolution that refers to all minutes, or do we have to stick to committee minutes?
Mr. Threet.
Through the chair, I believe that the call on this is up to the task force. The complaint, while it speaks to committee minutes, the layperson in making a complaint may consider the task force a committee. And it appears to me that the clerk was fully apprised and responded as if it was a complaint against all of the minutes. So there's not really an issue of due process.
Member Wolf.
Yeah, I do have a question, because there's another issue to this too, and that's a matter of timeliness on an IDR. And it's not quite clear in the write-up here whether that request was fully complied with or not, considering that the IDR was made on April 27th. So I'd like to ask Mr. Rustum if he has complied with that IDR, considering you asked for a 10-day extension.
Through the chair, yes, Member Wolf. I responded the very next day saying that I'm requesting a 10-day period because I had to contact all the members to get your feedback.
And did you deliver that information to Mr. Piccarello?
Yes.
Mr. Piccarello, did you get that information?
Well, as previously stated, I did an IDR, and the response back was timely, 1 day, saying that he couldn't respond in 1 day because there was too many emails. He
but
did respond.
Did you get the emails?
Sorry?
Did you get the emails?
There was none to give me. He didn't supply me maybe one or two things that were tangentially related to my complaint, but there was nothing. There was no communications that he gave me regarding the communication between the task force and the board, the clerk of the board. Okay. But initially he said he couldn't give it to me in 1 day because it was too voluminous. There was no documents to give me in his second response.
Okay, great. Thank you.
Member
Chairman, I
Coffin.
just wanted to point something out, that the request asks for problems in filing timely and or accurate minutes for the prior 12 months. So I think it would be appropriate for a chair, the clerk not knowing what existed, to take the extension so that he could look and find out what existed, rather than, I don't think it would be possible to get back by the end of the next business day either. We do have to, I do have to remember that Mr. Rustum does all the minutes which I previously talked about, in addition to being clerk at meeting. I think the job is a huge job, and he does much more than prior clerks. He does much more than the clerk that I was referring to, whom everybody absolutely loved. But she just refused to do the kinds of minutes that I think Mr. Piccirillo would like, and we did not require it.
Is there public comment on this item?
Members of the task force, Ray Hart, Inspector, San Francisco Open Government. As you know, I have been dealing with the Library Commission regarding minutes, and there are a couple of issues I like to raise. One is that often the minutes to me are something where a person who cannot attend each and every meeting of a particular group can look at those minutes and tell reasonably what occurred in those minutes in that meeting. In other words, they can get an idea of who was against something, who was for something, and some little idea. Simply saying that somebody spoke in favor of something really doesn't give anybody an idea as to what they were opposed. And as a result, you may not have any idea. You need to go back and listen to the audio tape, or in some cases, you have to go out and buy the audio tape to actually listen to what was said. I find it also really, really questionable in that the 150-word statements, which the law clearly says should be included in the body of the minutes, the Library Commission has fought over and over and over again because they don't want it in there. And I think the reason they don't want it in there is they do not want a 150-word statement put together by the person who actually said what they said next to the way they interpret it. Because if somebody looks at the two and they're right next to each other, they're going to go, that doesn't reflect this. Because basically what we have is we have a government civil servant who is substituting her own or his own interpretation of what the person said in place of what they actually said. And I think free speech in this country is free speech. And if I'm willing to take the time and make the effort to put my 150-word statement together to ensure that the points that I came up to make are adequately reflected, I think they should appear not replaced by a government censorship. And that is what? And, they will deny it up and down and backward and forward that that's not what they're doing. But when you listen to somebody or you read something that somebody wrote and you put it down in your words, it's censorship. It's manipulation. It's control. And I think it's an issue of a Brown Act statement because they don't like, in most cases, if you got up and you said, hey, I think you're the greatest thing since sliced bread, I don't think anybody's ever done as good a job as you guys are doing, they probably wouldn't have any problem putting it in. What they don't like is the fact that some of us get up and say, I don't really think you're doing a very good job. I don't think you're really looking at some of the things you should be looking at. And I think that basically it is an allowance for people to deny the responsibility. With the Library Commission, one particular issue, they had a city librarian who was...
Mr. Hartz, we're not talking about Library Commission. We have a specific complaint before us, and so far I haven't heard you address it.
I am addressing it. How I choose to address it is how I choose to address it. You may not feel it is, but my words are mine to choose.
Proceed.
Okay. So the whole idea of the minutes is one. The minutes should be something that a person who did not attend the meeting should be able to read the minutes and get a fair idea as to what happened and have some idea as to whether they want to go back and get the actual tape, audio, SFG TV, and review it to really get the facts.
Thank you. Further public comment on this item?
Deborah Benedict, I am not in any way, shape, or form legally skilled, but I can say that talking about various items would not jog anyone's memory, even if they were on the board, to be able to know if the person had spoken. I mean, if there was a bullet point about this person spoke about bullet points, this person spoke about, something that was about the Library Commission. I mean, I understand the idea that there's a tremendous amount of work involved in this, and that when you receive drafts, that, they're not supposed to be the complete. But if there was, if a person is speaking in 3 minutes and they have the ability to make 2 points or 3 points, even if there was just a jog so that a person would have an idea of roughly what they covered, unless they're completely illogical, there should be some bullet point or some keyword that would be able to trigger someone to be able to look into that area, I would think.
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. Further discussion? Member Wolf.
I would just say I would take what member of the public Hartz had to say about the 150-word written statement to be included in the minutes. I think everybody should do that. Then it can't be refuted what the person has wanted to have printed in the minutes had said.
Further discussion? Roll call, please.
Could you repeat the motion?
Okay, the motion is to find violation of 67.16.
Thank you.
Roll call, please.
On the motion, Member Snyder?
No.
Snyder, no. Member Cawthon?
No.
Cawthon, no. Member Manna?
No.
Manna, no. Member Costa?
No.
Costa, no. Member Wolf?
Aye.
Wolf, aye. Member Chan?
No.
Chan, no. Member Johnson?
Aye.
Johnson, aye. Member Nee?
No.
Nee, no. Mr. Chair, there are 2 ayes
And 6 noes.
and 6 noes.
The motion fails. However, again, we are aware that there are problems. We perceive problems with the minutes as well as the complainant. And although this motion fails, we do intend to pursue this matter further with the clerk of the board. Thank both sides for attending. At this time, we're going to take general public comment on items not appearing on today's agenda.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. And I apologize, I'm trying to balance going to the Board of Supervisors meetings and coming here. This past Thursday at the Rules Committee, Supervisor Wiener had put in an initial initiative that he wants to sponsor, which would allow the Board of Supervisors to change initiatives, including voter-proposed initiatives, after 3 years in place, and then after 7 years, it would allow them to even repeal them. And I tell you, this is the biggest grab for power I have ever seen in my life. Number one, the way it was handled in the committee, Supervisor Wiener was not a member of the committee. He was allowed to sit on the dais with them. He was given unlimited time to present all his reasons why he wanted to have this initiative. And then the members of the public were each given 2 minutes. Then Supervisor Wiener was given an additional 10 to 15 minutes to explain why all the things that the public had said were incorrect. It basically says a couple things that were said. One was that there was nothing that he was looking at that he was particularly focused on. And I find that hard to believe. I think with all the problems the city has, if a supervisor has spent the time to go forth and do all the research and form an initiative and is putting it forward for the board to consider, he wouldn't be doing that if he didn't have something in mind. One particular one I think he has in mind is historic preservation, and another is, I think, this body. And I'll tell you, after 3 years, they can dissemble for 3 years, and after 3 years, they can simply do what they call technical changes, but which what I feel will be is gut the meaning out of whatever that initiative is. They will simply change something having to do with enforcement or some other thing that will change it, and then say, oh, well, we really didn't do very much. I think this is the only way that the citizens of this city have to get control of a board that is going in a direction the citizens of this city do not like. And basically what they're saying is, let's have this so that after 3 years, if we get something that the citizens pass and we don't like, we can go back and change it. So I would encourage on June the 2nd, which is a Thursday, there's going to be another meeting of the Rules Committee, and there are as many people as we can get there that can show up and say, look, this is not something we want to do. If you want to change your initiatives, more power to you. But the voter-approved initiatives, those that are initiated by the citizens of the city, should be left alone because they are to be changed by the same people who proposed them and the citizens who voted for them.
Thank you. Is there further general public comment?
Yeah, I just wanted to apologize for my tardiness. I just wasn't here at the proper time. The other thing too is I wanted to submit video evidence for the agenda items that I had missed. Could I possibly get some information regarding how and where to submit those things?
Thank you. Is there further general public comment? Seeing none, general public comment is closed. Well, we wanted to go back to item number 1, but Member Chan has stepped out, so that would again, with two recusals, that would again leave us with only 5. So we.
Yeah, I'm going to have to step out about 5:45, and I'll come back as soon as I move my car.
Understand. Okay. However, Mr. Pitts is now here, and that would take us back to item number 4. We've already affirmed jurisdiction on this, so Mr. Clerk, could you read item 4, please?
Yes, Mr. Chair. Item number 4 is hearing on complaint filed by Charles Pitts against Supervisor Jane Kim for allegedly failing to respond to an immediate disclosure request for public records related to Shelter Monitoring Committee applications.
Thank you. Mr. Pitts, please approach. Thank you for coming, sir. You have 5 minutes.
Okay, I think there's several things. Well, the first one is I asked for information. One, I got it late, and second, I didn't get all the information. So one of the things is on the video here, it was shown that all 3 of those members had received like an envelope full of documents. And on all 3 of them, I have not received any of those documents. Jane Kim sent a bunch of emails, and I was asking for a broader scope of information. You know, so I get emails from Jane Kim, and then I get a bunch of scribbling from Ebenez, and it just felt like everybody else was providing me with something different instead of the information that I requested. I mean, well, not the information that I requested, but they all provided me with something different, and I still, at the end of the day, did not get all of the information.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Oh, sir?
Thomas Piccirillo. What's the concerns is that Mr. Pitts went in front of the Rules Committee applying for a seat on the Shelter Monitoring Committee, and he was denied appointment to the seat. What he did was he subsequently requested information from Supervisor Kim with an IDR for communications concerning discussions about his appointment, either for or against. Supervisor Kim did not respond at all for a long period of time. Supervisor Kim is a lawyer. She's chairman of the Rules Committee. I subsequently had a discussion with her aide showing my displeasure at Supervisor Kim not responding to the IDR, since she is a lawyer and presumes to know the Sunshine Ordinance. Mr. Pitt is not a potted plant. He's entitled to a response on an IDR. There was no response. And then there was a subsequent response by her aide indicating that they misunderstood the IDR. And if you look at your packet, the IDR is pretty clear as to what Mr. Pitts wants. So Supervisor Kim needs to be educated on the Sunshine Ordinance. Thank you.
Thank you. Is there anybody else to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Thank you for coming, sir. You have 5 minutes.
Good afternoon, members of the task force. Could
you identify yourself, please?
My name is Matias Mormino. I'm a legislative aide with Supervisor Jane Kim.
Thank you.
As your documents that should be enclosed in your packet explain, we misinterpreted the request from Mr. Pitts to be on communication regarding himself specifically, and the appointment to the Shelter Monitoring Committee. Finding none, we failed to respond to the request, stating that we had not found any information. Subsequently, rereading the request, we noticed this mistake that we made, which was that he actually was demanding information or requesting information on all appointments for the specified Shelter Monitoring Committee. We subsequently looked up all the communication incurred for any candidate applying for that, and we submitted the new information to the task force and the staff person at the task force. We sincerely apologize for the mistake in interpreting the request, and we remain really committed to openness and disclosure as per the Sunshine Ordinance, but also, as Mr. Pitts and Mr. Piccarello said, Jane Kim is a lawyer and she does believe in open government. So if there's any specifics that you want me to go over, what our procedure usually is when we get EIR is to look through our electronic documentation in detail, searching both for subject lines and included text in email communication or in any documents, and reporting immediately. We, again, sincerely apologize that both in the first moment we didn't report that we didn't have any relevant information, and then in a second time we misread the request by Mr. Pitts, but remain committed to open government.
Thank you. Is there anybody to present facts and evidence in support of the respondent? Seeing none, the matter with the task force. Mr. Pitts, could you approach, please? Of the information that you have requested from Supervisor Kim, is there any that you have not received?
It's a lot. First of all, if someone could actually get the computer started, I would show you. They handed the Rules Committee an envelope full of documents, and I didn't receive any of that. The other thing too is I requested for emails, letters, phone calls, and calendars between Jane Kim and the others. So they made it very clear that they brought people in and interviewed them. So I got no records of that. In the other document that I received from the other supervisor, I got a bunch of scribblings, which was supposed to be the phone calls. I didn't get any of that from Jane Kim. Their answer is very incomplete. I just think they don't They don't want, they're trying to hide something. And just when you look at their response, they responded excessively late. I just feel like the only reason I got any information from them is because I filed with the Sunshine Ordinance Task Force. And it still felt like even still late after that.
Thank you. Member Johnson, Member Wolf.
Mr. Pitts, I think I mentioned here in some of our meetings that I watched all of these kind of along with you to see how you would do on the sheltering committee before the rules committee. And I do know that there was quite a lapse between the time that the initial hearing took place and then they were waiting for a number of people that they wanted to apply, that they wanted to hear from. Do you happen to know if your request was made before or after the board? It went to the Board of Supervisors for approval.
Okay, I guess I need a little clarification. See, they had their meeting, and then I submitted. I guess I'm lost here.
You know, there were two. There was the initial meeting where you showed up and they wanted the Reverend to appear, and it took quite a while, like a month or something, for the second one to happen. Do you know? Do you know if? And then they sent their choices on to the Board of Supervisors. Do you have any idea off the top of your head if your request was made before their choices went to the Board of Supervisors for approval?
I'm definitely unsure.
Okay.
I'm unsure, but okay. I just think that, you know, between when I did my information request and when I heard anything from them was I think it was a violation of the Sunshine Ordinance and the California Public Records Act. So it just seemed like they just were not even caring about what the member of the public had to bring to the table. They, you know, the only reason I got anything back is because I filed here.
Thank you.
Member Wolf.
Mr. Mormimo. When did the Rules Committee finalize their decision and send it to the their recommendations to the Board of Supervisors?
I believe, let me double check. So the meeting was held on Thursday, February 3rd. So it went for a vote on at the full board, I believe, 10 days later.
No, that's not accurate.
No?
No. You didn't work there then, correct?
I was not on staff at that moment, so.
It went on for a significant period of time, so I just wanted to point that. That was only the initial hearing, and then they held it over to hear from other applicants for quite a number of weeks.
Okay, so we don't have an answer.
I don't have the date, but I know that that's what happened.
Okay. Okay, thank you, Mr. Mormino. Mr. Pitts, a couple of questions. You mentioned that in the video, we're not prepared, to be able to show it off the cuff right here, but I'll take your testimony. It's fine. You mentioned that somebody handed a pile of documents to the chair. Who was that?
It was Bernice. What happened was, I believe it was Bernice Cassidy who handed.
Who is that person?
She is the staff person for the Shelter Monitoring Committee. She definitely spoke as well about what the documents were. So it was her, and there was another Spanish lady that came up in.
Did you receive any of those documents?
Nope.
You received none of those documents?
Nope.
All you received is what we see in our agenda today, just the emails?
Yes, and I'm also thinking that when I first applied, I only had like one application in. And then the other thing that happened is they were looking for more letters of recommendation and stuff like that. And I submitted 4 more documents, and I didn't even receive those. So there's just a lot of information that was missing.
So you're saying that the documents that this particular, well, let's say for instance, this particular batch of documents that were physically handled at the meeting itself, you're not seeing anything you received from Supervisor Kim's office is not reflective of that?
No.
Okay, thank you. Mr. Mormino, I have 2 more quick questions. I noticed a stamp from the Board of Supervisors of March 21st at 3:43 p.m. For Mr. Pitts's complaint. And then I see a timestamp of May 3rd, 12:39 p.m. From your office with your signature on it. When did you decide to re-look at Mr. Pitts's complaint?
When we were, as I priorly stated, I wasn't working at the moment of the initial request, and there was a staff transitioning time. But we did not decide, but we took a second look once we were informed of the complaint, and we don't contest that, by Mr. Pitts to the Sunshine Ordinance Task Force.
And do you know if the supervisor did or does review complaints herself personally?
She does. They're usually looked at by staff and then discussed at our staff meetings.
But does she get to see them and read them herself?
Yes, correct.
Okay. All right, great. Thank you very much.
Member Johnson.
Through the chair to a question that Member Wolf had asked before, it looks like they held a hearing on February 3rd, and then it was held over, and the next one was on March 17th, which means that Mr. Pitts filed his complaint on March 21st, which means they, again, this is an issue of them not responding in a timely manner before the Board of Supervisors. Mr. Pitts requested documents where the Board of Supervisors was about to vote. And again, they didn't respond in time for that particular vote. Not that there would be public comment, but you don't really have it's not really up to us to decide why the requester was requesting is important or not, but still an IDR has a reason.
At this time, the respondent and then the complainant will each have 3 minutes to make any concluding or rebutting remarks. Mr. Mormino, do you have anything you wish to say?
We are committed to open government. We are committed to the Sunshine Ordinance, and we will do our best moving forward to respond in a timely manner. This is definitely unsatisfactory for our office too. So this is our position.
Thank you. Mr. Pitts.
Well, I definitely challenge what he's saying. If he's really if that office is really committed to providing the proper information and following the laws of the city and county of San Francisco, then they would give me the information that I requested. And that's what I want. I want the phone documents, the phone call records. I want the calendar. I want a copy of those documents, unredacted, that was submitted in the meeting. I was also told that Jane Kim received a phone call, and I got no type of documentation from them regarding this. So, if they're serious, give me the information.
Thank you. Matters back with the task force. Member Cawthon.
Before we do the motion, can I just make a comment to Mr. Mormino?
Please.
Mr. Moreno, I just wanted to, could you just come up a second? I just wanted to let you know, since you're new, that the city attorney has a really does extensive training on this. You can do it online, and the Sunshine Task Force also does. So that if you wanted some training, you could certainly ask our Education and Outreach Committee, and they would do a presentation. It's sort of good, I think, to have this kind of training because there's so many little jogs and whistles in the Sunshine Ordinance, just good to get the general scope and then some of the really important stuff. And you do intend to abide by it, you have said, so that it would be good to know what you will be abiding by.
Okay.
So thanks.
Thank you.
Thank you, sir. Is there a motion?
I move we find Supervisor Kim's office in violation of the Sunshine Ordinance for an untimely response and failure to describe why there is a withholding.
Is there a second?
Second.
Moved and seconded. I believe the sections we're dealing with here are 67.25A, which is immediacy of response to an immediate disclosure request. 67.21B, which has to do with providing the requested information. 67.26 or 67.27, which is failure to justify the withholding of information. And the chair would suggest a friendly amendment, 67.26, which is failure to keep withholding to a minimum. If the maker and the second will accept that.
Yes.
Okay. Is there discussion? Is there public comment? Is there public comment on this item?
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I would like to give the gentleman the benefit of the doubt and hope that he will actively learn the law and look at it not only in the sense of reading it from the strict reading of the law, but the intent of the law, and that is to be open with the government, open with the people in the conduct of government business. I have to, unfortunately, go back from past experience. And I'm using this as an example, which was what I was doing before regarding the Library Commission. When I went to the Police Commission, they had for 10 years failed to update the index of records. And they came in and said, oh, we didn't know, we were supposed to, and whatever. And well, you know, if you're a police officer and you stop somebody and they say, well, I didn't know it was the law, that isn't going to get you very far. And then they said, oh, well, we want to really, you know, we want to do what's right and we want to obey the law. And then what they did is they gave a posting on the index of records, which is basically meaningless. It is an index to nothing. You go there, and it says administrative records, and you click on the link, and it says administrative records. So basically, there are two ways that they can deal with this. If they are being open, if they are being honest, and if they are being legitimate and in their statements, then what they do is they come back and they say, we want to do a really good job in this. We went 10 years without following it all. And now that we realize we made a mistake, we want to do a good job. What they don't do is come back and do the same crappy job that all the other city agencies had done on the matter and then come up and say, oh, well, yes, we're trying to now do what is right. The proof of the pudding is in the eating. You know, if I really am sincere and I really do feel that you had a legitimate complaint and that I dropped the ball, I will then go the extra mile and make sure not only do I give you what you are entitled to, but I'll probably throw in a few extra things just to show you my intent is to comply with the law, not only its letter, but its spirit. Unfortunately, we don't always see that. What we see is somebody who will come back, give what they absolutely have dragged out of them. They will give the person the hardest, longest time to get it, and then they'll say, oh, yes, but we're trying to be open. You're either open or you're not. And as I've said before, public records are the property of us, you, me, all the other citizens of the city. They don't belong to the departments. They don't belong to the employees of the city. They don't belong to city government. They are the property of the people, and they have to be given to people who ask for them unless there is a legitimate and lawful reason for withholding them. And in this particular case, they did not even do that. So I would hope going forward they will take Ms. Cawthon's suggestion, get some additional training, read the law, actually read it, and ask them in their heart, if I were the citizen asking for these things and I read this, what would I feel I was entitled to?
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. Further discussion. Member Johnson.
I just wanted to correct one thing that I had said before. Member Costa has pointed out to me that the Rules Committee was continuing to hear this item. There's on page 62 of our packet, just for the record, the item was going on still in Rules Committee on April 7th. And I understand that the majority of the members of the task force are not as cynical as I am, but in the same vein, I want to point out that is, I think that makes not responding to the IDR all the more egregious, because that is taking away Mr. Pitt's right to testify at public comment before Rules Committee, because it wasn't turned over until after it had already been through Rules again. And he asked for it before then.
Further discussion. Roll call, please.
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Cawthon? Aye. Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, with 7 ayes, the motion passes.
Thank you. This matter is referred to compliance and amendments. Okay. That takes us, I believe, to item number 8.
Yes, Mr. Chair.
Would you read item number 8, please? And again, on this complaint, jurisdiction has already been accepted.
Item number 8 is hearing on complaint filed by Charles Spitz against Supervisor Mark Farrell for allegedly failing to timely and honestly respond to an immediate disclosure request for public records related to the Shelter Monitoring Committee applications.
Thank you. Mr. Pitts, please approach. Again, thank you for coming. You have 5 minutes.
Yeah, the cases are very similar with several different variations. One, they submitted those documents, and I didn't get a copy of them. The other thing too about it is Jane Kim. She sent me like 45 pages of emails, and Mark Farrell, he only sent me like 1 or 2 pages. So, and I'm just also under the impression, and I believe it's in the documents as well, where Mark Farrell, he received probably all of those emails or at least half of those emails. And he only sent me like 1. And I think also on top of that, I believe his response was late as well. So.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Is there anybody to present facts and evidence in support of the respondent? Seeing none, the matter is for the task force. Member Wolf.
Mr. Pitts. Now, if what you say is correct, I am looking at some of those emails from the previous case. I don't see Mr. Farrell's name on any of these.
Okay, because I was looking at.
So can you provide some evidence?
All right, let me look here. Let's try page 86. Yeah, top of the, top center.
Yes, I understand, but you had testified that that he should have also received some of the emails from the previous case.
Okay, well, these are, like you carbon copy something, and send it out. I believe this is what's happening, So
right, but like I said, I looked through some of those. I don't see any CC to Mr. Farrell's office, so I can't. I'm just trying to find if there's anything more than what is contained for this case, because if there is, I'm looking for corroboration here. If you're saying that Mr. Farrell's office should have gotten all of the same emails that Ms. Kim's office got, then we should have a duplication. There should be equal number of those. And I don't see them here. So
I wouldn't necessarily say all of them, but I would like at least say some of them, because you have.
Can
all
you
these
show
others.
me any? Because I don't see them. So if that's gonna be the allegation, then I want to have some evidence to back it up.
Well, I am just thinking, because you have all these carbon copies to all these different people, and I think one of them is one of their legislative aides. And but still, the primary case is still there with or without this, because one, they must have received some phone logs that I didn't receive, and then they still had that envelope that they received, that they didn't submit me anything about.
Thank you. Further questions? Okay, at this time, the chair will again ask, is the respondent present? Okay, Mr. Pitts, if you wish, you have 3 minutes to make any concluding remarks.
I think I just want all information. Maybe I was late and they were here and they left, but I just want my information.
Okay. Thank you. The matter is back with the task force. Is there a motion?
I would move for the same as the previous motion, as the previous item.
So you're moving to find violations of 67.25, 67A, 6721B, 6726, and 6727? Is that correct?
Yeah, but I don't think in 6725 we're dealing with the same issue. Hold on. March 24th.
Is that your motion, Member Wolf?
No, it is. Okay. Yeah, inclusive. Yes.
Okay. Is there a second?
Second.
Moved and seconded. Discussion. Member Snyder.
Just a question for everyone on the task force. Was there any testimony as to when the city Mr. Farrell responded? I see an email that is March 24th, which is 3 days after Mr. Pitts submitted his request. But was there any testimony from Mr. Pitts as to when they responded? Can I ask Mr. Pitts that? Do you mind?
Mr. Pitts?
Mr. Pitts, when did the email that we have in our records shows somebody from Mr. Farrell's office responding on March 24th? Was that the first time that they responded to you? Or did somebody do you recall somebody getting back to you before that?
Chances are it was late. I definitely believe it was late. If I would have received it on time, I wouldn't have put it in a complaint. Chances, let me just.
Do you remember anybody responding to you before this email on page 81?
Mark, it was Ebenez. He responded saying that he needed a 10-day extension, and then he missed the extension. He got the extension date. He missed the extension date.
I'm sorry, who was it that responded saying they needed the extension?
I'm sorry, let me see here. It was Ebenez. It was the other supervisor.
Oh, okay. But you're not saying somebody from Mr. Farrell's office?
No, it was the other one. I forgot it. I can't pronounce his name.
Ellsburn.
Yeah. He asked for an extension and didn't send it on time. So.
Yeah, but we're talking about Supervisor Farrell's
You're
office.
correct. But you asked if any of them.
No, I'm just wondering about Mr. Farrell right now. So, I mean, is it your recollection that that you did not receive anything before this March 24th email from Mr. Farrell's office? And
Well,
just
I think the
I'm
best
asking about if
I think the
anybody
best
from
answer,
Mr. Farrell's office
I think
responded.
I think the best answer to go by is. Let's see here. I don't think I received it on time. I don't think so. I think it.
When you say on time, what do you mean on time?
6725-A.
Yeah.
Pretty much like 72 hours.
I think it's earlier than that.
What?
So, okay. So it sounds like you're saying the first response you got was this March 24th email from Mr. Farrell's office, I mean.
Okay, let me see here. Because, see, let me just, because, okay, I filed on April 5th. And,
well, you submitted your request to Mr. Farrell's office on March 21st, and then it looks like somebody from Mr. Farrell's office responded on March 24th via email. But I don't see anything between those two. Do you remember anything between those two?
Mm-hmm.
Okay. Thank you.
Thank you, Mr. Pitts. Please be seated. Further discussion? Is there any public comment on this item?
Thomas Piccarello, thank you. Perhaps Mr. Pitts is wrong. I believe Supervisor Farrell did ask for an extension to give him the records, and perhaps Mr. Pitts' recollection will be refreshed. But my recollection is that Supervisor Farrell did timely respond when the IDR saying he needed more time to respond. Subsequently, though, he didn't respond at all to the IDR. I mean, the document request is pretty broad. There was no calendars by Supervisor Farrell given. There was no emails. The only documents that all three supervisors, and in this, I'll stay with this particular case, Supervisor Farrell gave, was communications by other applicants on the Shelter Monitoring Committee telling them that they no longer wanted to apply for the seats. So everything that Mr. Pitts asked for in the IDR was never provided by Mr. Farrell, Supervisor Farrell, or the other two supervisors. But I would like to say this, though. In defense of the respondent, I think they misunderstood your instructions, and that's why they're not here now. When you indicated you were going to table the matter, they think that this will be put over until next month. So you might want to consider that both Supervisor Farrell and Supervisor Ellsburn's aides were here at 4 o'clock. And I think they misunderstood your instructions about tabling Mr. Pitts' matters. That's why they're not here, and you may want to consider that. But in the final analysis, none of the supervisors, and specifically Supervisor Farrell, did not comply with the IDR by Mr. Pitts. No calendars, no emails, no phone calls, no communications. All the matters provided to Mr. Pitts were tangential, relating to other applicants who applied on the Shelter Monitoring Committee. Thank you.
Thank you. Is there further public comment on this item?
Task Force Ray Hartz, Director, San Francisco Open Government. I have to agree with Mr. Piccarillo, and the purpose of asking for an extension is the fact that you've looked into a matter, you've determined that it's going to be extensive or complicated or whatever, and you need the extra time to do it. And unfortunately, what happens is if you go and you take the extra time and you still don't respond, then you have to question whether or not the initial request for extra time was an honest request, or whether it was simply something that would allow us to just delay and perhaps drop it. And so, fine. If somebody says, I need an extra 10 days to do this, and at the end of the 10 days they give the response, or better yet, after 5 days they give the response, then you can say, hey, that was a legitimate request. They needed to do some research, and they did the research, and they provided it. In this case, they did not do that. And so I think it's also a question as to whether or not their initial request for additional time was legitimate, and whether or not that would be a violation also. Because, bottom line, if you didn't give it to them at all, then that extension really wasn't not used for a legitimate purpose.
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. Member Snyder.
Mr. Piccarello, could I ask you a question? You said you thought that Mr. Farrell asked for an extension under the IDR. On what do you base that?
I believe I saw the email from Supervisor Farrell's office to Mr. Pitts a day later, saying that he needed more time to respond. That's my recollection.
In our record today? You mean in the packet today?
It should be in your packet.
What's Ellsburn?
I'm sorry? It was Ellsburn that asked for the extension, not Farrell? My recollection is otherwise. Supervisor Farrell responded saying that he could not respond in the 1 day. Yeah.
Okay, thanks.
Yes.
Member Wolf?
Yeah, I understand all the broad requests from Mr. Pitts. I don't know, like with regards to calendars, whether there would be there could be, but I don't know if there would be any calendars notating meetings between the supervisor and the committee applicants. There may not have been, but without the respondent here to testify, it's hard for us to tell. We can't compel them to produce the documents unless they're here. I equally am a little disturbed by the response of March 24th that was on a public Yahoo account and not a City Hall internal. I find that to be a little disturbing. Yeah, I don't think there's much more to say to that. I mean, whatever was gotten was gotten. If there's more, we need the respondent here to question them about it. And the fact under Mr. Pitts in his testimony that there was more documents that were handed during the meeting, it would be interesting to know what and where those are.
Member Johnson?
I watched the hearings when they were going on, and some of the things you're referring to is they received letters of
recommendation.
Recommendation. Thank you. They received letters of recommendation, and there were some sort of requirement for one of the seats or two of the seats that they have recommendations specifically from certain homeless groups, and they were asking the applicants, can you provide that, and then they were asking the clerk, did you receive that, and then that's when this handing of documents went over. Or that's one instance that I personally saw.
Okay.
Further discussion? Roll call, please.
On the motion, Member Snyder.
Could somebody restate the motion? What was the motion for?
The motion is to find violations of sections 67.25A, 67.21B, 67.26, and 67.27.
Thank you.
Roll call, please.
On the motion, Member Snyder.
Aye.
Snyder, aye. Member Manny.
Aye.
Manny, aye. Member Costa.
Aye.
Costa, aye. Member Wolf.
Aye.
Wolf, aye. Member Johnson.
Aye.
Johnson, aye. Member Nee.
Aye.
Nee, aye. Mr. Chair, we have 6 ayes.
Thank you. This matter is referred to the Compliance and Amendments Committee. Approach, please.
Deborah Benedict, I had an issue up, and if Mr. Chan was here and the other supervisor,
Member
Coffin, was here, then there would be a quorum, but with them both gone.
They are both expected to return.
Oh, I didn't understand that.
Perhaps we should have made that clear.
I'm sorry, I didn't, because when Mr. Chan took off, I thought he was dashing for the door and gone. So, okay, thank you.
They both of them have informed us that they plan to return.
Oh, thank you so much.
Sorry,
okay.
sorry we didn't
Okay,
make
I
that
just
clear.
didn't understand. Thank you.
Okay, thank you. I believe that takes us to item number 10, Charles Pitts against Supervisor Ellsburn. Mr. Pitts, could you again approach, please? Again, thank you for coming, sir. You have 5 minutes.
Well, I think the variation in this case is I didn't receive any emails of any sort, but all I received was these scribblings, and that was about it. The variation in this case is that he asked, I received this letter as well too, but he asked for a 10-day extension, and then at the end of the 10 days, he didn't respond. So that's the whole thing. That's no emails, no phone logs, no nothing, except for these scribblings. And I'm actually just trying to figure out when these scribblings took place. So I guess once again, I didn't get the information. I didn't get it in a timely response. Although he asked for a 10-day extension, the extension time was late.
Thank you. Is there anybody to present facts and evidence in support of the complainant?
Thomas Piccirillo. Actually, I think this is the most egregious wrongful case. Again, Supervisor Ellsburn is a lawyer, and what he does is he relies on a 30-year-old District Court of Appeals case, Stanford University versus Superior Court, with the premise that privacy rights give him the right not to disclose any information that he received regarding the character, reputation, or credit-worthiness of Mr. Pitts. Clearly, that's not what the case held, and I applaud the Deputy City Attorney Dana for her legal memorandum. It really does set out the law for you. But again, what the position of Supervisor Ellsburn is that he doesn't have to disclose anything. The Rules Committee is a secret, closed committee, and that any matters dealing with their appointment process are subject to non-disclosure based on the constitutional right of privacy. That's not what the Stanford University versus Superior Court case said, and that's not the law. That's not what the California Constitution provides, the Brown Act, or the Sunshine Ordinance. So Mr. Ellsburn, relying on a 30-year-old case, it's not even a Supreme Court decision, that basically was a defamation action by a doctor against the university, and the doctor wanted personnel files of another doctor he was suing. This court held that the personnel file was discoverable, had to be given to him because it went to his reputation. In terms of confidentiality, only the person that gave the information, the name had to be redacted. But all the information, all the substance, all the discussions are disclosable. Thank you.
Thank you. Is there anybody else to present facts, present facts and evidence in support of the complainant?
Ray Hartz, Director, San Francisco Open Government. Bottom line is we have people appointed every day to boards and commissions in this city. And citizens ought to have the right to look at the documents that they submitted in the appointment process to determine what the qualifications, experience, and so forth. And if you start getting into this thing where, oh, this is confidential, that's confidential, I think my experience has been unfortunately more that it's the fact that the person wasn't really qualified, didn't have any specific thing you could point at that said that they would be a good person for that board, and they just don't want to have that come to the foreground. I'll give you a good example is the Board of Appeals. There is only one person on the Board of Appeals who has any experience in architecture, and that is Mr. Fung. He has a master's and a bachelor's in architecture, and the rest of the folks may be very nice people, but they have no knowledge of building codes or anything else. And California law basically says that anybody who sits on a Board of Appeals, when they're hearing cases having to do with land use and building permits and things like that, ought to have knowledge of building and construction and things like that so that they have a basic knowledge from which to work. Otherwise, what I have found in the case of the Board of Appeals, they are completely reliant on the city agency to tell them yes or no. And if the city agency says yes, they just go okay. And if the city agency says no, they go okay. And they have no real professional or lifetime experience to really challenge that. And when you go up and you say that to them, they go, oh, well, are you saying we don't do a good job? No, I'm simply saying if we had better qualified people, they would be able to do a more effective job and come to better decisions. And I believe that any commission or body that's unwilling to look at its own performance and determine whether or not there would be some things that they could change to make themselves more effective is doing a disservice to the public in general. They're simply hearing cases, checking them off, and that's the end of it. So all this information, once the person, and it's like a public employee. If a public employee gets hired, you are entitled then to see all of the information regarding their experience so you can really look at that and say, did the person they pick have the kind of experience you would expect for this position that they were hired for, or did they simply have an in with someone?
Thank you. Is there any further public comment on this item? I'm sorry. Is there anybody else to present facts and evidence in support of the complainant? Okay, seeing none, is the respondent present? Is there anybody else to present public comment? Is there anybody to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Member Johnson.
I didn't really think about this before, but is there, with all due respect to Mr. Pitts being here, I would really like to hear the legislative aide or Mr. Supervisor Ellsburn's explanation for a couple of things. Some of, responding to some of the things about the privacy issue of withholding. I mean, when you apply for boards and commissions and certain things, sometimes your whole financial information is up on the internet. So I would like to address that. And in addition, Supervisor Ellsburn's name appears on some of the emails that were given to us by Supervisor Kim and Supervisor Farrell, and I would like an explanation for having a 10-day extension and then not responding and then not including those emails. I'd like to hear that, so I don't know if the complainant would be willing to carry this over since there may have been some miscommunication.
Okay. We can handle that when at the appropriate time.
Okay.
Sarah, are there any further questions for the complainant? Okay. At this time, the complainant has 3 minutes to provide any concluding remarks. Mr. Pitts.
Just not much here from me. I guess I'm still an individual that's been slighted by the system, and I'm just trying to get the information. I mean, you're pretty much correct. The chances are he received emails and phone calls, and he might have had people come to his office to talk about the position. the Coalition on Homelessness and probably some of the service providers are going to probably lobby hard for their e-feet puppets. I just, so they're definitely going to work very hard to protect those type of people. And I'm just another person trying to do right by the city and county of San Francisco, and just looking for my information.
Thank you. The matter is back with the task force. Member Wolf.
In light of Member Johnson's question, I would move to continue this.
Is there a second?
Second.
Moved and seconded. Discussion. I kind of agree. There are some things in here, particularly in the response from Mr. Ellsburn's office, that I'd like to examine. Also, there is a question of when Mr. Ellsburn's office provided the information that it did. There's a question, there may be a 67.25A violation here, maybe not. But I find the citation of the Stanford case. I'm not sure that that's valid. The reason is that Stanford is a private institution, not subject to the CPRA, not subject to Brown or Bagley-Keene. So, the city and county are obviously in a different category here. Furthermore, I think the task force has held in the past that redaction of personal information must be done on an extremely limited basis. That being, I think personal phone numbers can be redacted, but not email addresses, and I believe not home addresses, residence addresses. And the reason is if somebody is applying for some kind of a city commission seat where there is a residency requirement, certainly, the public has a right to see that proof of residence. So, for that reason, I think it would be, I agree that it would be a good idea to present this to further discussion and examination, and to have somebody here from Supervisor Ellsburn's office. I also agree with Mr. Piccarello that perhaps we were not clear in letting the aides from Mr. Ellsburn's and Mr. Farrell's offices know that the hearings might actually occur this evening if, in fact, the complainant appeared. So, I don't see a 6721E violation here, but I do think these other matters certainly deserve further exploration. Is there further discussion? Roll call, please.
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Cawthon?
Aye.
Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 7 ayes. The motion passes.
Okay. Thank you. We did not take public comment. I'm terribly sorry. Is there public comment on this item?
No.
Okay. I apologize for the error. At this time, we will declare a 5-minute recess. We are back in session. 1, 2, 3, 4, 5, 6. We're back. Yes, we're back in session. Where were we? I believe we are now at item number 13. Is that correct?
Yes, Mr. Chair.
Okay. Could you call that item, please?
Item 13 is determination of jurisdiction on complaint filed by William Clark against the Arts Commission for allegedly failing to respond adequately to his April 6, 2011 request for information on certain funds.
Is there a motion to accept jurisdiction? So moved. Is there a second?
Second.
Moved and seconded. Discussion. Is there public comment on the jurisdiction question of this item? Seeing none, public comment is closed. Roll call, please.
On jurisdiction, Member Snyder. Aye. Snyder, aye. Member Cawthon. Aye. Cawthon, aye. Member Manny.
Aye.
Manny, aye. Member Costa.
Aye.
Costa, aye. Member Wolf. Aye. Wolf, aye. Member Chan. Chan, excuse. Member Johnson.
Aye.
Johnson, aye. Member Nee.
Aye.
Nee, aye. Mr. Chair, there's 7 ayes. The motion passes.
Thank you. That takes us to the substance of the complaint. Mr. Clark, please approach. Thank you for coming, sir. You have 5 minutes.
You're welcome. First, I'd like to give a copy of this newspaper article for evidence to show that my brother and I, for a long time, have been finding money. And I'd like to pass a few other copies around to the other members. I didn't make enough for everybody. You can browse through it. What this complaint involves is that a while back, when we were doing our budget for the previous year at the Arts Commission, we were informed that we were being charged $18,875.18 management supervision charge to the Arts Commission, to the Street Arts Program, because the Street Arts Program is a ballot measure where all the money that's collected pays for all the expenses, and that Mr. Kinsell advised us that since 5%, he said that 5% of his time he thought he spent supervising the Street Arts Program, that he was going to charge us for him and Jill Mantan this amount of money, and that this amount of money would be reimbursed to the general fund in order to keep the Street Arts Program cost neutral with the general fund. And so we were charged this money on the pretext that it would be paid back into the general fund eventually, and that way the city would not bear any costs for the Street Arts Program. And this was done last October. And I sent Mr. Kinsell an email, and I asked him if the money had been transferred into the general fund yet. And I received an answer 10 days later from Mr. Lazar, and Mr. Lazar told me that no, the money had not been transferred back into the general fund, and that there was no directive to put the money back into the general fund. So I asked Mr. Kinsell one more question. I said, well, does that mean that the money still remains in the Street Artists? But as of January 6th, is the $18,875.18 still remaining in the Street Artists Fund? And all that required was a yes or no answer of, well, if it wasn't transferred to the general fund and there's no directive to put it in the general fund, I'm trying to find out if it's still in the Street Arts Fund as revenue for the Street Artists Program. And I received no answer from Mr. Lazar or from Mr. Kinsell as to whether or not this $18,000 still remains in the Street Arts Fund or whether it's been used to pay for this bill. And I'd like to refer to Section 67.24, subsection F in the Sunshine Ordinance relating to budgets and other financial information, which states that other records of payment obligations as well as records of actual disbursements showing the amount of actual disbursements, showing the amount paid to payee and the purpose for which payment is made, are to be publicly disclosed. They're not supposed to be withheld. So I'm asserting that under this section, I'm entitled to know whether or not the general fund was repaid this amount of money, which we were charged to pay Mr. Kinsell, and that was supposed to get transferred back into the general fund. Because if it wasn't put in the general fund, I'd like to know where it is. I'd like to know if it's in the street artist fund or if it's someplace else. And to this day, like I said, as of right now, this $18,000, this is almost the end of the fiscal year again, and to my knowledge, this almost $19,000 still remains in the street artist fund and can be used next year for expenses. And so I just feel that it's pretty outrageous that I can't get a yes or no answer whether or not this money, which we were told very blatantly that, it's not going to, the street arts program isn't going to cost the city 1 penny. Mr. Kinsell said, we're not going to cost 1 penny. And I have to spend 5% of my time and Jill Montan's time overseeing this program. And as of now, our salaries are paid by the general fund. So we're going to charge you this amount. We're going to charge you for our salaries. Plus, they charged us an additional 10% also. So I'd like to get an answer to this question. Thank you.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Is there anybody to present facts and evidence in support of the respondent? Matters with the task force. Are there any questions? Member Johnson.
Through the chair, Mr. Rustum, did you hear from the Arts Commission about attendance today?
Through the chair, Member Johnson, the Arts Commission did not contact the office.
And you sent through the chair, you sent a
yes, Member Johnson, it was sent on Friday.
Okay, at this time, the complainant, if he wishes, has 3 minutes to make any concluding remarks.
I'd just like to make a couple of quick statements again, saying that you understand that we were yelled at and told very blatantly that that they had to spend so much time overseeing our program. And for 40 years in the past, we were never charged this supervisional management charge by the city. This charge was actually charged against us at a secret meeting that took place a month after the end of the fiscal year. And we were told that this was decided by the management team of the Arts Commission. And then upon us asking for other information through the Sunshine Ordinance, we found out that the management team that held this meeting was Jill Montan and Mr. Kinsell. So they basically voted to give themselves this money. They did it a month after the fiscal year ended. There was no committee meetings, no public meetings were ever held, and then we were told that we were being charged this so that the general fund could be made neutral. And to this day, the money hasn't been put in the general fund. And I'd just like to say, I think this is, it's at the last 3 hearings, the Arts Commission didn't send anybody. The last hearing, the city attorney didn't send anybody. At this hearing, the Arts Commission isn't sending anybody. This is a yes or no answer. It's very simple. And I think that if there isn't a case for willful, misconduct, simply not giving me this information, I shouldn't have to come down here to get a yes or no answer. And actually, we all shouldn't have to be here to do this. And I think that something has to be done so that, as you see, I've found missing money in the past, and there's another $250,000 that was collected, that was unused, that was put into the general fund. And I believe that there's a conspiracy by the city and the city attorney's office to cover up the fact that there's this embezzlement, that our money was used to pay for city municipal purposes, which is illegal. These fees are only supposed to be used to administer and enforce the Street Arts program. They're a special revenue source. They're a special fund. And we were told by the city, even though this is a special fund, our money isn't held in trust, and therefore they can use it for other city purposes. I mean, if public funds aren't held in trust for the purposes that they're supposed to be used, I think we're living in Alice in Wonderland. And I just want to reiterate that I'm getting upset now because I came here to get answers because I can't get answers to these questions at the Arts Commission. Thank you.
Thank you. The matter is with the task force.
Mr. Chair.
Member Wolf.
Well, I don't know if continuing the item would compel them to come the next time. I don't know that. I mean, obviously they're not showing up. We've had this situation over and over again. Finding willful failure, we can obviously do that and send it off to the Ethics Commission. But again, this would be an interesting answer to hear in this particular instance. So I'm compelled to continue it to see if they'll show up the next time.
Is that a motion?
I'll make that motion.
Is there a second? Motion dies for lack of a second. Is there a motion to find violation? Member Johnson.
Part of me wanted to agree with Member Wolf's motion because I'd like for them to respond, but it's hard to continue because I feel like they won't appear.
Well, through the chair, I mean, on this particular case, there isn't anything that's so time certain, and to continue it, I don't think would necessarily affect the outcome or the needs of the complainants at this point. The idea is to get them to show up so that we can have a day and have them in front of us for the day. We haven't had anybody credible from that office to answer anything worthwhile for some time. So, to me, if this is a game that they're playing on us, I'm willing to. I'll play ball too.
My inclination is a little bit the opposite of yours because I'm inclined to make a motion to find violations of 6721B, 6722A, 6250, the CPRA 6253D, CPRA 6254C, and the Sunshine Ordinance 6734, because it's becoming pretty clear that they're willfully not attending.
Well, there's that too.
Now, I don't know necessarily that we should only send that to the Ethics Commission. I think we got to spread around the information that they're willfully not attending, although this is directly, I think it should go to the Ethics Commission and to the Board of Supervisors because this is about budgetary issues.
Mm-hmm.
Is that a motion?
Can I ask?
Yes.
Is there a second?
Second.
Member Wolf?
Yes, I second.
I'm sorry, Member Snyder.
Didn't the last vote, somebody correct me if I'm wrong, but I think on the last vote we had involving the Arts Commission and Mr. Clark, we resolved, so we found a violation, and I think we said we were going to send a letter to the Arts Commission about the repeated failure to show up. Does anyone else remember that? Am I remembering some other?
I don't remember that.
maybe I'm remembering a different item. I thought we were going to send a letter saying essentially
We were going to send a letter to the Board of Supervisors.
to the Board of Supervisors regarding the Arts Commission. Right. So, just as possible, just suggestion here, we could say, well, first off, I don't think there's any question on the facts that we have in front of us that there are several, violations of several sections for this complaint. We could incorporate in that letter that was to be sent this, let me start over. If we decide to continue this item, we could include this continuance in that letter and say, this is an effort to get them to come. There's a particular issue that involves basically a binary yes/no response, and the Arts Commission isn't responding. And we've continued it in an effort to give them more than they're entitled to explain why they're not responding, or to explain why they've withheld this information. That way, we're sort of establishing a trail to say, here is the basis for our willful violation later, if it comes to that. And we can say, look, we gave them an extra opportunity. We sent a letter to the Board of Supervisors saying that they've failed to appear at multiple hearings. They didn't show up. Even then, they didn't show up. And that, to me, would seem to be a more solid factual basis on which to find a willful violation. So I guess I'm just saying I would add to Did you actually have a motion, Member Wolf?
There was a motion that
was
not, that died for lack of a second.
Right. Okay.
There was a motion to continue that died for lack of a second.
Yeah.
Well. Okay.
And then Member Johnson was intimating.
We now have a motion on the floor that has been seconded to find violations of 6721B, 6722A, 6726, 6727, and CPRA sections 6253D and 6254C.
I have a friendly amendment.
Those aren't what I said. I have 6221B, 6222A, 6253D, 6254C, and 6734. But if members are inclined to leave a paper trail that Member Snyder is suggesting, I would consider it if and only if there is mention made that the Arts Commission is intricately connected now, or Louis Cancel and Howard Lazar are, well, this says Mr. Cancel had something to do with this, that they are intricately connected to that Twitter deal and the revitalization of Market down there, which is a highly protected project by the supervisors, and that if they're really representing that they're going to make that an arts area, then they should be respectful to the street artists in San Francisco that even make that possible. Without mentioning that, I think they'll just protect them. I want it to be made clear that we're watching the city as a whole, not just this one teeny tiny little part. Because I saw Mr. Cancel and down there celebrating the black arts, gigantic art that's down there. And that's something that they, want to push forward in the public eye to make them seem that they're supporting the artists. But San Francisco is pretty much built on the street artists. I don't know how you would mention that, but it can't just be vague, because I feel they'll protect them from it.
Member Wolf?
I was going to suggest something else, but I'm not sure how I can make a connection. I understand what you're saying, but I don't know how we can make that. It sounds like a supposition versus factual.
What do you mean? It's not a supposition. He was down there celebrating the opening of that black art.
I understand that, but we don't have any testimony or evidence of that. And to make a supposition that whatever this particular issue, how do we make the connection?
My point is that without putting that in front of them, I believe that the letter will just sit there and they'll protect them from it. So it means I won't withdraw my motion. I want it to be more, if you want to create a paper trail, you can, but in San Francisco, politically, when something's being protected for another project, a paper trail is meaningless. We think that it'll have meaning, but without pointing to things that ruffle their feathers, they'll just sweep it under the rug.
Through the chair, I completely understand what you're saying, and I understand where you want to get to with this. I just can't see how to make the connection, because there's no evidence to show that connection.
That they're representing
they have anything to do with that, the Twitter deal or the area around the Twitter deal.
Well, Mr. Kensel was there opening all of that. It's not the
But
Twitter
there wasn't
deal.
any
It's
testimony
that
to that.
It's the Market Street. The point of that, the PR around that is that it's going to be an arts area.
But it's not germane to the complaint. And unless we can find some germanity to the complaint, we can't include something that is not within the target. So I would feel a little uneasy about including something which would be taken as rhetorical that is not germane to the actual complaint. But I get your point.
You're sending it. You're not. The letter has to do with them not appearing, not with the complaint. I mean, it's about the complaint, they're not appearing, but it wouldn't be about the fact that there's this money unaccounted for. It would be the fact that it appears to be a willful violation of them not appearing, right? Isn't that what the letter? Did I misunderstand? I mean, I was thinking that Member Snyder wanted the letter to say that it was repeated offenses, and we're trying to get them here for this complaint.
I believe the letter is actually not meant to refer to the Arts Commission or staff specifically. I think the letter, if memory serves me correctly, is to alert the supervisors that a number of departments show a pattern of not appearing, of not sending knowledgeable representatives when we have hearings in which they are respondents. I certainly think that in that regard, the Arts Commission people are among the most egregious, if not the most egregious, of those offenders in that particular respect. And I would certainly, be inclined when I write the letter to mention the Arts Commission specifically. But again, back to the question of this specific complaint, I think if we try to bring things into it that are not into the complaint, we start to tread on a little bit of risk, because the Ethics Commission and the Board of Supervisors, particularly the Ethics Commission, they use any excuse they can to allow respondents to skate, and I'd prefer to keep this kind of straight and narrow.
Well,
Mr. Threed?
Through the chair, in the interest of offering options to the task force, it appears that a motion previously was made to send a letter to the Board of Supervisors about the Arts Commission and other entities. That motion having been made and passed, it's already been adopted by the Commission. At this point, I think it would not be appropriate to change what that letter is directed to. But on this particular case, certainly the task force is free to move to send another letter. And in light of the recent positions that the Ethics Commission has taken on willful violations for failure to appear, one option within that framework might be for the task force to send a letter to the Arts Commission and the Board of Supervisors directing that the Arts Commission appear at the task force next meeting and directing that they comply with an order of determination that's adopted today, and if they don't appear at that meeting, then within the Ethics Commission's own rubric of how they see enforcement, that would set it up for the task force to refer it to ethics for willful violation.
The order, an order today would set that.
Point is taken, well taken. However, our procedure usually is, if we find a violation on this, the order of determination would first direct that this go before the Compliance and Amendments Committee, and that gives additional opportunity for complainant and respondent to make their cases. And then, if there is not compliance by the time this reaches the Compliance and Amendments Committee, then it comes back here to the full task force for possible referral. You know, our usual, I think in this case, our usual procedures will more than suffice. Member Johnson, and then Member Wolf.
My reluctance is that we don't need to create a paper trail. There is a paper trail. All you have to do is cite to it. They haven't been here a number of times. You could create a brand new one, sending it to the Board of Supervisors. I mean, I haven't seen a great response from them, but I mean, you could create a new one, but I just want to point out that you could also say, here's the list of the times that they were supposed to appear and they didn't appear, or here's a list of the time, here's when they stopped appearing and started sending someone that just read their, couldn't, and in fact, there was an outburst from the representative complaining that he had to be here at one of our recent meetings.
Member Wolf.
So I would be more inclined to send a letter to the supervisors et al., whoever else you want to send it to, asking the same question that the clerks are asking in their complaint, and saying that there's been no response from the Arts Commission, that they have not shown up, and that we feel that there might be, this demands an investigation by the Board of Supervisors as to find out why and how and where this money is, so on and so on and so on. I mean, the point is we can have them show up at Compliance and Amendments, and we can ask them all kinds of questions they will or will not ask for. But if you start putting this kind of question with regards to misappropriation of funds in front of the supervisors during the budget cycle when these things are being decided, that's certainly going to raise a few hairs. And I would be more inclined to run that through the gauntlet and see what kind of response we get from that. I mean, I don't think in all the years I've been here we really have ever tried to affect a financial decision in that kind of way.
Okay. There is a motion on the floor right now. The motion is to find violations of 67.21B, 67.22A, 67.34, CPRA sections 6253D and 6254C.
That would be a friendly amendment then.
Okay, so
Well, I was trying to figure, since other people seemed inclined to create a paper trail, I was trying to find a happy medium to withdraw the motion. So.
Who made the motion? Member Johnson made the motion. Member Wolf seconded. Are you withdrawing the motion, Member Johnson?
Well, there was no decided alternative, so no.
Okay. Member Wolf has suggested a friendly amendment.
For the letter you just suggested?
To include the sending of a letter to the Board of Supervisors. Okay. The chair, is that acceptable to the maker of the motion?
Are you speaking of the letter that Member Wolf just said about
That's
asking
correct.
The question?
That is his.
Yes, it is.
Okay. The chair will suggest further friendly amendments to add to the list of violations 67.21E, 67.26, and 67.27. 67.21E is attendance by a knowledgeable representative. 67.26 is keeping withholding to a minimum. 67.27 is failing to explain the withholding, provide justification for the withholding. Are those amendments acceptable to the second and to the maker?
So the letter is in addition to the violations or instead of?
No,
in addition to.
Oh, okay. Yes, yeah.
Yes.
Is there further discussion? Is there public comment on this item?
Good evening, Robert Clark. I just wanted to make a couple of comments. My memory of the letter that you people had agreed to send on the last matter did directly relate to the R Commission, and you had made some comment that you wanted to tell the Board of Supervisors and the mayor that a track record has been established in regards to the R Commission not complying with the request of the Sunshine and North Task Force. And in addition, you made some kind of comment about requesting the possibility of the Board of Supervisors withholding future funds from the Art Commission until they start complying with the Sunshine North Task Force. That's my understanding. To the gentleman here, I just want to let you know that we do have a couple more complaints coming up in the next month or so. And I think it will establish whether or not they are ever going to send anybody else to this committee again. So I respectfully would have disagreed with your request to continue it, because I think we can solve that problem by seeing how they how they react to the next complaints. If nobody shows up at those hearings, I think it will become obvious that this is just a willful decision on the part of the Arts Commission that they are not going to cooperate with these questions and the Sunshine Task Force because, as I said, when I went to the Art Commission, I was told verbatim that they wouldn't answer any of my questions. And so it's kind of forced us here through the Sunshine Task Force. And I think what we're seeing now is Mr. Kinsell's refusal to answer any of our questions dealing with finances. And I just want to say that, as dealing with the Art Commission for 40 years and being one of the people who started the Street Arts program, my brother and I spent years collecting petitions. We put this initiative on the ballot, and we think that what's happening here is that the city attorney and the Art Commission realize that my brother and I are collecting evidence against the Art Commission to prove that they have illegally amended a ballot measure, they have embezzled funds from our program, and the city attorney is aware of the fact that the city attorney has been covering up this information, even to the degree that they appeared. We filed criminal complaints against members of the Art Commission, and we went in front of the grand jury, and we believe that the city attorney filed a fraudulent opinion with the grand jury to get our complaints dismissed. And the more, I'll finish in a second, and the more we come before you, I think the more you're going to realize that there's something very seriously. And I really like your suggestion to ask that question.
Sir, your 3 minutes have
Thank you very much. That question is excellent.
Thank you. Further public comment?
Task Force members, Ray Hartz, Director, San Francisco Open Government. I think sending it to compliance and amendments would be kind of a wasted effort. If they don't have enough respect for this body as a whole, they're certainly not going to have enough respect for an individual committee of the body to send someone. I would also say that, yes, it's all well and good to send a letter to the Board of Supervisors or to the Ethics Commission, but I would send an additional letter directly to the governing body of the Arts Commission with a copy of the letter you're sending to the Board of Supervisors and indicate in there that, we are very concerned about the fact that you failed on numerous occasions to send someone. It was a great inconvenience to us. It was a great inconvenience to the person who filed the complaint. And the reason I would say that is because every city agenda has know your rights under sunshine, and yet when someone does know their rights under sunshine and chooses to exercise their legal rights, they are castigated. They're made fun of. They're treated like they're just gadflies or just all the horrible things, and yet they fail to ever acknowledge the fact that they are the ones who are under the law. They are run by someone who has signed an agreement to understand sunshine and ensure that it is followed in their respective organization, and yet they can't even work up enough of an effort to get someone come here to talk about the issues. And very honestly, that shows bad faith. And I think I worked in the insurance company for 3 years teaching insurance to people. And basically one of the worst things you can ever accuse an insurance company of is bad faith. That you have a claim, it's a legitimate claim, you know it's a legitimate claim, and you still refuse to pay it. They have this complaint, they know it's a legitimate complaint, and they simply just refuse to pay. And I think sending the letter to the Board of Supervisors is one thing, but I would, again, put a cover letter on it and send a copy directly to the governing board and let their board of directors take it as an issue. Let them be aware of it and say, hey, don't say that we didn't warn you. We sent repeated things. Now, some of you may think I'm a real pain in the ass, but I think one thing you can honestly say is I've never failed to show up when there was a meeting in which I was involved. And the only couple times I did that, I was ill, and I called somebody because I respected not only your time, but also the time of the other party, because I'm not doing this for grins and giggles. I'm doing it because I think these matters are serious, and they need to be handled in a serious manner. And basically what we're seeing here is a total lack of professionalism on the part of the Arts Commission.
Thank you. Is there further public comment on this item?
Thomas Piccarello. I believe in the maxim, justice delayed is justice denied. This is the second or third time the Arts Commission has not showed up. I have no confidence in the Board of Supervisors doing anything for you. The district attorney does have jurisdiction in this matter for willful violations. And if there's allegations of financial irregularities, perhaps a letter to the district attorney's office might be more appropriate. Thank you.
Thank you. Is there any further public comment on this item? Seeing none, public comment is closed. Is there further discussion? Member Wolf and Member Costa.
My thing is it's really kind of about like a due process. I mean, you can continue to bring complaints, more and more and more complaints, but we're going to end up always at the same place. And even though it may reveal something, in front of this body and in this public forum, it doesn't mean that it's going to have legs to go anywhere else. We have to put legs on something, and we have to make it go somewhere. We have to try some new and other, maybe not so innovative, but try something new that we haven't done before, and try every other angle we have to get somebody to pay attention, because they're not paying attention. And if it's not going to be someplace outside this room, then I don't know what else to tell you except to sue the city and get it in front of a real court of law, because that's the only place it's really going to be on the record. We saw that happen with Mr. Grossman, and he was just asking for documents, based on a process, not even the results of it, just what the procedural documents were, and they felt compelled to settle. So I would suggest that we do what we plan on doing here today. We see what the letter will produce. We should follow up on that letter to the supervisors and see if there's any kind of outcome. And if there isn't, then we'll proceed as we do.
Member Costa.
I tend to agree with the idea, though, that it would be more effective to be trying to get them in front of the full task force rather than the Compliance and Amendments Committee. I feel like I both sort of intuit that they're more likely to show up, and that it would be what might come out of that sort of meeting might be more fruitful.
Then, Mr. Chair, I would suggest that instead of referring this to compliance amendments, that the task force as a whole, it could be a committee of the whole, retain this item.
Well, I don't think we have to make this an either or. I think we can make this both. You know, the task force doesn't meet unless we have a special meeting. The task force doesn't meet for another 5 weeks.
Right.
The Compliance and Amendments Committee meets in another 2 or 3 weeks. So we can make it both. And particularly if there is non-compliance by the time that the Compliance and Amendments Committee meets, we take it back here. That's what we normally do anyway.
Well,
Further discussion. Member Wolf.
I will commit that if they don't show up by the next task force meeting, that I will walk that order of determination over to the Ethics Commission, and I will deliver them in their public forum and not directly to the staff.
Further discussion. Roll call, please.
On the motion, Member Snyder? Aye. Snyder, aye. Member Cawthon? Aye. Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan?
Aye.
Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, there are 8 ayes. The motion passes.
Thank you. We now have 8 members here. That means that we are able to proceed with item number 2, which is complaint number 11021, Deborah Benedict against the Tides Center. Ms. Benedict, thank you for coming. You have 5 minutes.
Oh, wait, we have to recuse those folks again.
Yes.
Okay.
The 2 others.
Okay. Members Costa and Manet. And I've been advised by the clerk's office that in cases of recusals, the recused parties are asked to leave the room entirely.
Okay.
And we will, when we resume other matters, we'll bring you back in.
Send up a flare.
That too.
Okay, so I guess
So you guys...
Members Costa and Manek? No, the recusal has already been done.
No, Robert's rules, too.
Thank you for coming. Ms.
Thank
Benedict, you have 5 minutes.
I am not a full expert on sunshine law, but I do believe that if you're going to be advertising a meeting that is supposed to be available for the public, and that meeting is cross-country in thousands of miles away, and there's no opportunity to have a phone-in number to call in and to request the opportunity to listen into the meeting, that really doesn't qualify as one of the 2 meetings that sunshine law allows for the public to be able to attend meetings. I would find it quite cost prohibitive to fly cross country to attend the Tides meeting, and if they had included a telephone number, I would have dialed in, because I know that the organization does good work, and I'm interested in what they do at a board level to handle the organization. So that, in essence, is my complaint. I don't know, since it is such a large organization, if they have a possibility of having phone-in, or if they have a possibility of having board meetings here. But I would imagine, since it's a national organization, that phone-in might be the only thing if they're going to have them in New York all the time. But I don't have any answers. I just know that as a member of the public, I have an interest in the group and would be interested in being able to attend, whether that's in physical form or electronic form, and that opportunity was not provided in the notice. Thank you.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Seeing none, the respondent, please approach. Thank you for coming, ma'am. You have 5 minutes.
My name is Eliaton Callender Scott, the governance manager for Tides, and I'm responding to the complainant's comments. According to the rules and regulation of the Administrative Code, we have no obligation to set a dial-in number or to have telephone conferences. This is the first time it's come up, and that's the only response I have to that.
Thank you. Is there anybody to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Member Wolf, Member Snyder.
Wait for her to finish. Ma'am, before you leave, I'd like to ask you a question. And can you repeat your name again?
My name is Eliaton Callender Scott.
Okay, thank you. I'd like to ask, are you familiar with the 12L requirements?
Yes, I am.
Okay. Do you have at least 2 designated public meetings per year?
Yes, we do.
And how many of them are on the West Coast?
That would vary from year to year.
You're required per year to have
2 public meetings.
2 public meetings that are available to members of the public here in the city and county of San Francisco.
In the last year, we have had 2 public meetings. In the last year, 12 months, we have had 2 public meetings on the West Coast.
Okay. Have you had any meetings this year?
Yes, on the West Coast, no. We've had 1 meeting, and it's been in New York.
Are you planning on having a meeting on the West Coast this year?
More than likely they will be. I do not know the schedule for the remaining meetings.
So there is a requirement to have at least 1.
I'm sorry.
There is a requirement to have at least 1. It says at least 1 designated public meeting. The public shall have an opportunity to address the Board of Directors on membership on the Board of Directors and to propose candidates for membership to the Board of Directors as provided.
There is a plan to have at least 1, yes.
Okay. Okay. So, okay, thank you. One moment. Ms. Benedict, your complaint is in with regards to meetings of 2011?
Yes, actually, I didn't do the research, but I will do the research to find out if last year there were 2 meetings held in the West Coast.
What is your complaint?
This complaint is about this year, and I guess I wanted clarification from the commissioners to just please tell me, are they required to have something physically here?
Well, they're required to have a public meeting for members of the city and county of San Francisco, of which they're getting funded for. Okay, so they have to make arrangements. If it's not going to be here, it seems obvious, and I'll get some consultation. I'll ask for some consultation from our legal counsel on this, but we'd have to make some way for the members of the public to be able to respond to them in real time. So it doesn't matter what that medium is, whether they fly you out there or whether they set up a teleconference or they set up a video conference or something like
honestly,
that. Hold on, let me.
Sorry.
Can't talk at the same time. That would be their requirement. Now, they're supposed to hold 2 designated public meetings per year, of which the members of the public here have an opportunity to address them. At least one of those meetings has to be made available to them if they're having an election, so that members of the public can address the candidates for the membership of the board of directors. You follow what I'm saying?
Is it only on public meetings that where board members are being elected?
No, only one meeting. They have to provide one meeting
Here.
or provide it to the public in real time.
Okay.
So that they may address them. If it's going to be in New York, then they're going to have to find a way to get you out here to be able to ask questions or observe the meeting for that membership. But that's one meeting.
Okay.
Okay. If they were only going to have one meeting, it was only going to be in New York, and they weren't going to have an East Coast, West Coast kind of thing.
Mm-hmm.
That's where we start running into a violation issue as far as I'm reading this. On all other matters, they got to have at least 2 designated public meetings per year.
Okay,
Now, hold on. I'm going to defer. I'm not going to defer. I'm going to ask our legal counsel for some.
Before we proceed any further, I have a procedural matter to raise.
Yeah.
Did we accept jurisdiction on this?
I think we did in the beginning.
Mr. Chair, I think we did it last meeting.
At
on
the last
18th,
meeting?
yes.
Okay. Thank you. Mr. Threet?
Excuse me. Through the chair, Member Wolf is correct as to the one meeting per year for the Board of Directors voting on members and suggesting members to serve on the Board of Directors. However, there's a separate requirement in 12L4C regarding public comment. Subsection 1 says, at every designated public meeting, the public shall have an opportunity to directly address the Board of Directors on any item of interest to the public relating to the operations of or services provided by the nonprofit organization. So both public meetings, that opportunity has to be made available to members of the public.
Very good.
Thank you. Member Snyder?
Through the chair, I'd like to ask Member Threet, do you think, is there a question at all in 12L that when it discusses members of the public, it means members of the public in the city of San Francisco? In other words, if they held a meeting open to the public in New York City, would that suffice?
Through the chair to Member Snyder, it's a close question, but given the core intent of this ordinance is to provide the citizenry of San Francisco the opportunity to examine the board of directors of an organization that's receiving funding from the city of San Francisco. And there's a good amount of city services that have been, through contracting, shifted to nonprofits. And so the purpose of this was to provide at least some transparency and ability to understand what those organizations are doing. So in light of that intent, I think the appropriate way to read members of the public is members of the public of the city of San Francisco.
Thank you, Mr. Threet. Member Wolf?
I would just like to add that within that same section, they're required to allow for at least 30 minutes of public comment, not per person, but total.
Further questions? Member
I have
Coughlin?
a question. I'm not sure who knows the answer. Have we determined that they receive, whether or not they receive $250,000 a year from the city?
Yes, we have.
They do? Okay.
Yes.
Okay. Further questions? Okay, at this time, Member Wolf?
I would just say, okay, never mind. I'll wait till we're done with the rest of the process.
This time the respondent and then the complainant will each get 3 minutes to make any concluding or rebutting remarks. Ms. Caliender-Scott?
I have no further comments. I understand the commission wants the dial-in number if the meetings are not held in San Francisco. At least that's my understanding from comments made.
Thank you. Ms. Benedict?
I believe I need this explained to me fully, that I was, again, that one meeting, there has to be 2 meetings, but they don't have to be both in the city of or on this side of the country, and only one of them has to allow a period of time when there's either an election. I'm kind of stating this back to you because I really am needing to get clarity, because my understanding was that 2 meetings were required, and that my understanding was also that they were open to the public meetings. And if one meeting is cross-country, I guess, does that count as one of those meetings or not count as one of those meetings? I mean, does it? I don't know. That's what I'm not clear on. So that's, and that's, I guess, if, since there is a remainder of the year, if there's time, of course, that there's many months, or at least 6 months, if they, have a meeting that they announce and they provide that dial-in number and a way for that to be done, then that would satisfy the 1 meeting if that's all that's really required. So thank you.
Thank you. The matter is back with the task force. Member Wolf.
Okay, so just to help with a little clarification, Section 12L.4.A1 describes 2 occurrences. One is they shall designate and hold at least 2 designated public meetings per year, and the condition of that are available for public viewing and comment by the residents, the citizenry of City and County of San Francisco. The second one is 1 meeting. There has to be at least 1 designated public meeting specifically dealing with the election of the Board of Directors. Okay, so it could be one of those 2, I suppose. But the 2 that are in the beginning of that Section 1 is specific around the information, the general nature and significance to the nonprofit organization issues, the issues with regards to what the Board of Directors might or might not take action on. There is a caveat that with regards to any extent allowed by state or federal law. So if there's any state or federal law that might provide them with additional conditions, either more stringent or more liberal, those would then supersede. And the only other caveat is if they provide abortion counseling or services, domestic violence, sheltering services, suicide prevention counseling. So I hope that clears things up.
Member Snyder.
I just wanted to add to that. The bottom line is that every public meeting, there has to be an opportunity for the members of the public to directly address the Board of Directors on any item. So as soon as a public meeting is designated, there has to be some form of opportunity for people in San Francisco to directly address the board. And so that means they could hold the board meeting here. That means they could I suppose they could hold it in New York, but make a telephone conference, number available. But the bottom line is whenever there's a public meeting, there has to be an opportunity for the public to comment.
Is there a motion? Seeing none, the matter is concluded. Thank both sides for attending. Mr. Clerk, I believe that takes us to
Item 14.
Item 15 and 16.
Let's send up a flare.
15 and 16, yeah.
Can we send up
Could
a flare?
we bring the other task force members back in, please? Mr. Clerk, we are on item 15 now. Could you excuse me?
Just a point of order. I think we may have overlooked something on the last The last case with regards to DCA 3, revealing Section C with regards to at every designated public meeting, public shall have an opportunity to directly address the Board of Directors. Ms. Benedict's. Oh, yeah, I'm sorry. Thank you. I just don't want to be a travesty of the justice here, and Member Snyder did point this out. It states that no matter what, that every designated public meeting, public shall have an opportunity to address the Board of Directors. In this case, a meeting had already taken place, and there was no opportunity, and that's why Ms. Benedict actually filed a complaint. So I think, in the interest of justice, we must find in violation of 12L.4.C.1 or subparagraph 1. And I'll move that.
And I would second that. I think that 12LC1, as DCA 3 pointed out, makes clear. I'm going to repeat Member Wolf a little bit, but just to clarify, at every public meeting, every designated public meeting, the public, which I think we can reasonably take to mean the people of San Francisco, have to have an opportunity to directly address the Board of Directors, and there was no such opportunity with this meeting, given that it was in New York and there was no teleconferencing available. So I would second the motion to find a violation of 12L4C1.
Just C, because 2 couldn't have been, 2 just says how the period of comment would be.
Right, C1.
Yeah. So it would be both, just C.
12L4C.
12L4C.
Okay, there's a motion to find violation of 12L4C. And motion second. Any discussion? Is there public comment on this item?
Thomas Piccirillo. Yeah, this case shows the importance of contemporaneous and accurate minutes keeping. If you look on your packet number 201, you will see that the issue of jurisdiction for the nonprofit has not been addressed. It was continued until tonight's meeting. So you need to, I believe, find jurisdiction first before you make a decision regarding the nonprofit. Thank you.
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. Further discussion? Member Wolf.
Yeah, Mr. Chair, I don't think it was my recollection, and I guess in this way I'll have to go back to the audio. It was my recollection that the 2 members had recused themselves, and then we did take determination. But we didn't, but the item was continued. So do you have a copy?
Yes, at the special meeting of May 18th. Determination of jurisdiction on complaint filed by Deborah Benedict against the nonprofit Tide Center. Member Snyder, seconded by Vice Chair Wolf. Motion to find jurisdiction. Yeah. Motion carried 7-0.
Yeah, that's in a separate document. It was handed. Yeah, it should be on the table. So, I'm sorry?
Jurisdiction, it was item number 11.
It's May 18th, Tuesday, May 18th, special meeting. It should be on the table.
Item number 11. Further discussion. Is there further public comment on this item? Seeing none, public comment is closed. Further discussion. Roll call, please.
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Cawthon? Aye. Cawthon, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan?
Aye.
Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, there's 6 ayes. The motion passes.
Thank you. This matter is referred to the Education, Outreach, and Training Committee.
Mr. Chair, will the order be, or the ruling be sent to the Tides? Will they get notification of this?
Yes.
Oh, they will. Okay, great. Because they're not here. They left. Oh, you are here. I'm sorry.
Okay. Can we bring the other two members back in, please?
No, it was separate.
Didn't you get a copy?
Even though it's on. Oh, no, I didn't get it. But here, I can look at his. I can look at.
Give you a copy. You can have your very own.
I can look at my very own. I didn't want to take yours. Thank you.
Mr. Clerk, could you read item 15, please?
Yes, Mr. Chair. Item number 15 is determination of jurisdiction on complaint filed by Frank McDowell against the SFMTA for allegedly not providing adequate response to his March 16, 2011 request for information on a drive cam.
Is there a motion to find jurisdiction?
So moved.
Moved and seconded. Discussion. Is there any public comment? Sir, please be seated. For the moment, please be seated. Is there any public comment on the jurisdiction question? Seeing none, roll call, please.
On jurisdiction, Member Snyder?
Aye.
Snyder, aye. Member Cawthon? Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan? Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 8 ayes.
Thank you. That takes us to the substance of the matter. Mr. McDowell, please approach. Thank you for coming, sir. You have 5 minutes.
Thank you for having me. Your Honor,
Please speak into the microphone.
yes, I'm a municipal operator in the union TW 250A. The Muni has installed camcorders on the buses under the guise of training. Since Proposition G, Muni has been using the camcorders for disciplinary action against the employees. Our rule book specifically states that no third-party actions can be used against an employee. Furthermore, there is no professional guidance, audio, or photography, nothing other than a computer operated by the municipal railway management. Our union is nowhere involved in the operation of the cameras or operation of the outcome of the cameras at all. Furthermore, the answer to my complaint was untimely. The papers that I asked for is not the papers I asked for. I asked for all disciplinary actions to show that their Muni's discipline is based on extortion, and rather than disciplinary. Their action is punitive rather than for training purposes. There is no retraining. For instance, I've supposedly had 3 incidents for breaking incidents. Muni put out bulletins. They said under their bulletin it states that a camcorder light could only come on for hard braking, hard turning, or collision. But I put up a termination saying that I do a rolling stop. Now, we have malfunctions with our motor coaches' transmissions. You get a jerking in the transmission. It's called retarder action. When that retarder action kicks in, the light comes on. Muni want to call it a rolling stop. Again, Mr. Haley, the manager over motor coaches, has stated that braking, hard braking, hard turning, or collision could ignite the camcorder. we have street cars, cable cars, and the F line. They don't have camcorders, but we are all up under the same umbrella. We're up under the TWU umbrella. There's no disciplinary action going towards these employees. Under Title VII of the Discrimination Act, no one could be treated differently. The street car, cable cars are not being disciplined under these camcorders. They're under Title VII. In the letter that I sent to you under the Sunshine Act, I mentioned the words retaliation and harassment. Under the Discrimination Act, management had 5 days to either send this to the EEO. No management has sent it to the EEO to this date. Now, I asked for, in my letter to the Sunshine Act, dated March 16th, not answered until May 6th. I'm asking under the Sunshine Task Force Act, Section 6254, that you provide a matrix on all discipline as a result from drive count. This is what was sent to me. Now I have to show.
Can you pass that forward, please?
We have that in our
We have
packet.
it? I'm sorry.
I want to show how I want to show if it's they've been disciplining people for adjusting a mirror, for calling what we call a 702 for bathroom breaks.
Okay, Mr. McDowell, your 5 minutes have expired, sir. Please conclude your remarks.
The camcorders are disparate treatment. They are not on all muni coaches, not on real coaches, and we want. I want all records for discipline, and I want the camcorders to cease from being used as disciplinary actions.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Thank you for coming, sir. You have 3 minutes.
Good evening, Task Force. My name is Dorian Maxwell. I do support Mr. McDowell's request to get the information about the matrix on the disciplinary actions that's been transpiring against muni operators in retaliation of us voting down 2 no concession votes. The discipline matrix, I have received one that I did Sunshine, and they did furnish the information. They redacted the names of the employees and their employees' IDs. And they do expose the disciplinary that transpired for that individual in the amount of time that they serve, whether it's suspended or terminated. I do have that document in my possession, but I don't have it in front of me right now to show. As you all know, that my case made the newspaper because of the frivolous activity that's going on at the SFMTA with regards of discipline, trumped up charges, even withholding of information that could exonerate a person or I can't think of the word right, convict a person. What Mr. McDowell is asking for is nothing much more than just getting information to support his discipline or whatever his case. He just wants a case law so he can have as a reference if he has to go to file a lawsuit in respects to the outcome, because there is some nepotism going on in the SFMTA where people that do commit the same crime, they get slapped on the wrist and they get put back out there. For instance, like the lady with the cell phone. She gets slapped on the wrist 3 days, but they got another operator that's up for dismissal, and he probably was his first time on the cell phone, and he gets put up for dismissal. So there's some nepotism going on there, and Mr. McDowell should be entitled to the documents, the information, so he could prove his nepotism case if it has to end up in a lawsuit. Thank you.
Thank you. Is there anybody else to present facts and evidence in support of the complainant? Seeing none, would the respondents please approach? And the chair will ask the complainants and respondents, please stay in or close to the front rows so that if we call you up for questions, you won't feel too much like a yo-yo. And it'll save us time and energy. Sir, thank you for coming. Please approach, and you have 5 minutes.
Good evening. My name is David Hill. I'm the Deputy Director of Transit Management.
Please speak a little closer into the microphone.
Okay.
Thank you.
Okay, my name is David Hill. I'm the Deputy Director, Transit Management for SSMTA. First of all, in regards to Mr. McDowell's request, he is correct. He did submit a request on March the 16th. His request was submitted. We don't know to who it was submitted, but the reason we know it was submitted is because it was time-stamped. It was time-stamped upside down, and so we did not reply within the 10 days simply because we weren't aware of it. When we went back and looked at it, what we found out was that there was a lot of information that was requested in the letter, but down in the body of the letter is where the actual request was made for the information. He made another request on April the 27th that he gave directly to the superintendent, the acting superintendent, Cheryl Turner, and that was right at the same time that I came here the last month, and not fully aware of what Sunshine was about and so forth and so on. So on April 27th, he made another request, which we responded with the information that we had, and we got it to him by May the 6th. Now, there's been a lot of things that have happened since I last appeared before you. Last month, as I came before you, to be quite honest, it wasn't very pleasant at all, at least on my side, and now I can understand why. So leaving from this meeting, I went the very next day, and I contacted the office of the city attorney, Dennis Herrera, and I requested that they would send some attorneys over who really knew the Sunshine Act and the law, and I wanted to be trained, and I wanted all of the people in operations trained. In fact, this body recommended that we do online training or that I put together a training program. Well, I've only been in California 2.5 years, so I'm really not the one to put it together. So they came on May the 12th. The two attorneys that came from the city attorney was David Greenberg along with John Kennedy. They presented a 58-slide PowerPoint, and I'd like for everyone to look at it. It took 2.5 hours, and I made sure that every superintendent and everyone that could possibly, in a division, get a Sunshine request was there that was up underneath my management. I also made an offer to all of SFMTA and tried to explain to them the seriousness of everything. This is a list of the superintendents and all of the secretaries so that in the future we would know how to handle any Sunshine request and to make sure that everything that we get is read from top to bottom, because if it says Sunshine request or says open information request or whatever, we're going to get it to the proper place and make sure that it is that someone responds to it. So the information that was given to Mr. McDowell When a person is disciplined, we don't have like a matrix that says everything on one category. If someone is disciplined, you're called into the office. Maybe you're late for work. Maybe you were running sharp. Maybe it was a drive cam video, whatever. That information is entered into their own personnel file. Now, when the other person came up, Mr. Maxwell, he said that he was able to get the information, but it wasn't in a matrix. What he had was the information on a particular person that was whited out. So no matter what the discipline is, it's entered into employees' records. Now, how this came about, because I said, after being here, I said, if anyone knows anything or has a matrix of any kind, even if it isn't the exact thing they're requesting, I want to make sure that the person gets it. So Labor Relations had this, and it was basically some grievance data. When someone filed a grievance, they would put a little check mark, but it wouldn't say exactly what the discipline was or whatever. So whatever we had, we gave it to them. And so that's it. So in the future, from the operations perspective, that goes for me, everyone that's up underneath my management umbrella. We're going to abide by the rules, and we're going to make sure that we respond. And now we know what the rules are, so there is no excuse. Thank you.
Thank you. Is there anybody to present facts and evidence in support of the respondent? Seeing none, matters with the task force. Mr. McDowell, please approach. I have a question for you. Is there any information that you requested that you have not received?
I haven't received any information that I requested. What I need to show is what nationalities they've been disciplined, what nationalities. Like myself, they claim that I did a rolling stop. I want to know who's been what rolling stop. Some people have been adjusted for adjusting a mirror. Some people have been disciplined for using the restroom. They've been abused. They've been using the camcorders, and it's in our contract.
Okay, sir. Let me just try to clarify what it is you're after. You're after racial and ethnic data on discipline. Is that correct?
All data that they collected money for telephones, for use using the camcorder for telephone use, catching people for telephones. Our contract calls for no third-party involvement, but they've been using the camcorder for disciplinary action. The paperwork that they handed you, the discipline was not being used at that time. They've handed you just a color-coded framework. Title VII clearly states that you cannot discriminate. Again, there's no camcorders on the street cars, the F car line, or the cable cars. They have stops. They have stop signs and red lights, just like the motor coaches does. You cannot. It cannot be any disparate treatment.
Okay,
also,
we understand, sir.
Also,
We understand about the disparity of treatment, but that's not what the task force has to deal with. The task force has to deal with the fact that you are claiming that you requested certain information and have not received it, and we want to narrow our discussion to that. Okay.
Yes, sir.
So, again, from what you just told us, my understanding is you are asking for a racial and ethnic breakdown of discipline administered. Is that correct?
Racial, of all racial, who's been disciplined? Yes.
Okay.
And what type of discipline?
And what type? Okay. And
under the camcorder.
And you are saying, and you are saying that none of that information has been provided?
No, it hasn't.
Okay. Do you have a copy of our information packet in front of you, sir? Because I would point you to pages 135 through 138. There seem to be some charts here.
Those are charts, but at that time,
In the microphone, please.
if you see the dates,
In the microphone, please.
if you see the dates of these charts, discipline was not being used at this time. I have evidence of camcorder use. There was only discussions at that time.
Okay. In your information request, did you specify dates for which you'd like information?
I asked for all discipline.
All discipline. Did you specify any dates? Because if you say all discipline, I'm not.
What I specified was I'm asking under the Sunshine Act to provide matrix on all discipline as a result of drive cam.
Okay. And when did drive cams first appear on the buses?
I think maybe 2009. That's the papers I gave you, and I got it up to 2010.
Okay. So you're saying you did not get information for 2009, and you did not get information for whatever information there is for 2011. Is that correct?
No, discipline only began after we took a no vote on to Proposition G.
Proposition. I'm sorry. Which Proposition G are you talking about?
Proposition G is what we're in negotiation for now to alter the charter amendment for the municipal railway.
Okay. The reason I ask is that we have a Proposition G that we often refer to here, and Proposition G passed in 1999 is the current version of the Sunshine Ordinance. That's why I asked. We needed the clarification. Okay, so what you're saying then is that there is a lot of information. There is some information here.
There's no information here. This was no discipline at this time. This was a training. This was a person would come in and they'd have our training officer would discuss an incident with you. There was no discipline.
Okay, thank you. Member Wolf.
Oh, a question for the MTA.
Will I get the copies of that?
Mr. Hill?
Please pass this back.
So Mr. McDowell refers back to Prop G several times. Are you aware of anywhere in Prop G that expands the use of drive cams for the purpose of discipline?
No, sir. Prop G has nothing to do with drive cam at all.
Okay. All right, thank you.
Excuse me. Member Johnson?
Did you have a question? Mr.
Go
Hill, I appreciate your being active in training the other members of your staff. Could you expand on, I don't know if I should ask you or Mr. McDowell, but could you expand on when discipline based on the cameras actually began to be enforced?
When they first came on, he is correct. When they first came on, basically there was no discipline at all. There was a period of adjustment where everyone adjusted to it, and it was initially told to the union that it was, and employees that it was going to be used as a training tool. Now, somewhere down the line, there was some kind of disagreement, which I wasn't a part of, that no, it was just for a short period of time, and then they would start issuing the discipline. The union contends that no, it was always supposed to be a training tool. Now, as far as this discipline here, they never did track it. What happened is for this period, and the reason you only see this period, someone asked the question, was drive cam really improving the driver behaviors? And that's why they tracked it for this period, just to compare the two, and that's why you see the comparison. And that's why you don't see it continuing on.
So there's the time frame that these cover, there was no active enforced discipline based on the cameras.
No, on this is actually showing enforcement on there. The time before that, there wasn't any enforcement, but once the enforcement started, it's continued all the way to even now.
So
enforcement
these
is continued.
represent the enforcement.
Right, enforcement for a period of time.
Okay.
I have another question for Mr. Hill. Considering what Mr. McDowell just told us about the information he wants, is there any kind of requirement either in the union contract or in the NLRB regs or the state labor regs or the equal employment opportunity regulations that require you to keep any kind of breakdown in terms of race, gender, ethnic origins, anything like that of disciplinary proceedings?
Okay. By me being only in California 2.5 years, I don't know enough about the state and how the rules are here. What I have learned is things are different in this state. But I can say from an MOU perspective that there are no requirements. However, when the MOU was originally written and approved a couple of years ago, they didn't have drive cams, so that's one thing. The second thing is that we have legal, we also have labor relations and so forth and so on, and I would think that if it was a requirement, I would think that that would be something that they would adhere to. But I really can't, say for sure. I'm not going to say, well, yeah, to me it doesn't make sense that it would be a requirement, but honestly, I don't know enough about the state laws.
More directly, does the MTA keep that kind of data?
No, they do not.
Thank you. Member Wolf. And then Member Coughlin.
I would, in preparation for this, I tried to do a little research on the drive cam since it's come up before us several times. And what I did find was a press release dated November 3rd, 2009 from the MTA. And there's a quote from James Doherty, who's the Director of Safety, Security Enforcement, that says operators who engage in unsafe behavior must be trained or disciplined. So that's an overall statement. The drive cam will serve as a vital component of our training system. It doesn't speak to anything about discipline. So I find that interesting because I couldn't find anywhere that, all I could find in everything related to drive cam was just all about training. Nothing about discipline. So I just found that interesting, and I wanted you to know that as part of what we're dealing with here today.
Member Coughlin.
Mr. Hill, I had a question for you, and I also wanted to say something. This is not on the drive cam, but it's on this training document. Because I know we do training, and I think this is a great document for the EOTC. I have never seen it before, but it specifically speaks to what the employees need to know and what kinds of, in a whole bunch of good situations. But my problem is, was this the way you got this with a black background? Or was there is this print out backwards on this paper?
Well, the sheet that you have is that what I did is I had to make copies of the presentation so that we wouldn't only just get the 2.5 hours and hear them explain it piece by piece, but that everyone could make notes and have a copy of the presentation.
Right, this is a good document. My question is, did they give it to you like this with a black background?
Yes, ma'am.
Oh, really? God, I'm going to have to talk to them. This is very hard to read. There's green. It looks like it was printed backwards. Right. There's green printed on black.
Well,
and they gave it to you in this form?
Yes, I also have a whole list of, just to give you an idea of, as we're going through, this is just the first page of the questions I had.
You said John Kennedy and David?
David Greenberg.
Okay, I'll call them. Thank you.
Okay, you're welcome.
Further questions? Okay, at this time, Mr. Hill, at this time the respondent and then the complainant each have 3 minutes to make any concluding or rebutting remarks. Mr. Hill? Yes. If you have any concluding or rebutting remarks you'd like to make, you have 3 minutes.
Okay. The only thing I'd like to say is I apologize. I know that ignorance is not an excuse, but most certainly when I came last month, I had no idea. And the things that I said is I'm a person of integrity. I say the truth, and basically, so someone said, well, you're not telling the truth because I have it right here, but I was really referring to something else. So didn't sleep good that night thinking about how I could get this thing fixed. So from now on, I'm not going to consider it a burden. If we have to come here, I'm going to come. But more importantly, if there's anything that anyone requests, I'm going to make sure that we get it so that we don't get to this point. Thank you.
Thank you. Mr. McDowell, you have 3 minutes.
We have defective machines. I bought these machines, the buses, to my superintendent's. I told my superintendent about this. Again, we have retarder problems. The retarder kicks. It's a transmission. It's called a transmission. It'll kick and it will make the light come on. I've explained this to the superintendent. I'm a 20-year employee. All of a sudden, they have no matrix for discipline. First discipline, they want to give me 3 days. The second discipline, they want to give me 5 days. That's a total of 8 days. The third discipline is up for termination. 20 years. You know, I think is excessive. There's no retraining. This camcorder is supposed to be for training purposes. They've exceeded, and everything they've done is borders on extortion. There's no retraining. There's nothing but money, discipline. There's nothing. Thank you.
Thank you. Matter is back with the task force. Member Johnson?
I'm not sure, this may be a point of order or somebody with more experience with the cases. Normally, I hesitate to say that there's the requirement that the city employees or the custodian of records help the requester narrow down their request. But this is kind of, his request was a little bit broad, so it's kind of hard to figure out exactly what's missing. Or maybe I'm missing, if they work together a little bit more, is that something we might ask to figure out what he wants, to see if that's available as opposed to trying to find a matrix? Was there any kind of interpretation? I mean, the drive cams are going to be an issue. They're at issue. I mean, there was a real famous one recently where Supervisor Wiener was on the underground and the doors opened in front of him and they posted that all over the place. So, I mean, they're going to come up, but it just seems so broad. I don't know if somebody with more experience of cases has seen this before, where the request is so broad that it's difficult to understand what they want. No? You don't think so?
Member Snyder?
I'm not familiar with any cases that address that issue, but that doesn't mean there aren't any.
Or even
I'm
here?
just not familiar with any.
Are sunshine cases here?
Through the chair to Member Johnson, it essentially is a judgment call for the task force, and the task force on various cases before it has come out different ways on this particular question. When a complainant makes a specific request and the respondent searches for that particular request and doesn't find what they want, I think you need to look at the request and determine whether it should suggest to the respondent that they should ask further questions or not. And the task force, as I said, I think it's a judgment call, and the task force has come out different ways on different phrases that the requests have had.
Is there a motion? Okay. Absent a motion, we will ask for public comment. Is there public comment on this item?
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I spent about 4 years on the staff of the Commander-in-Chief Pacific Fleet, and one of the responsibilities I had was to investigate EEO complaints, and there were some things that I learned in that process. One is that most organizations, whether in the public sector or the private sector, don't keep information relating to how things break out ethnically or racially or male, female, or whatever, unless they're forced to. Mainly because they don't want to have anything sitting there where if they look at it, they go, oh, we got a problem. They wait until somebody files a EEO complaint or whatever, and then if part of that complaint forces them to go back and start to keep track of it, then they do that. The police department does that on traffic stops. They now have to keep all the information on traffic stops to ensure that officers aren't racial profiling and do other things like that. But they normally, if they do that, it is because they've been forced to do it as a result of a lawsuit or a complaint with the EEOC or whatever. So it kind of sounds, from what I heard, like they got a question from the people who were responsible for the cameras being put in, a question saying, well, we put the cameras in. Is there any difference in what was before and what there is now? So for a certain period of time, they kept the records, and that was what they provided. And then from my hearing of this, at that point, they said, okay, well, we gave them the information they wanted. We're not going to keep this anymore. So they may not have the documents or the information covering the specific period which is being requested, which would be not an unreasonable thing. So unless there is some sort of a requirement that they're under a court order or finding that says they have to keep track of this because of past problems, then they may very well not look at this. And it's not something that normally most organizations look at because they, like it or not, just make the assumption that we treat everybody fairly. And until somebody sticks their feet to the fire and says, well, we've got some people saying you aren't and you need to keep track of it, they don't, simply because you don't want to make problems where there aren't any.
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. The chair will again ask, is there a motion? Member Wolf.
Yeah, I'm having a lot of trouble trying to figure out here what the issue, where the only motion I can make is on timeliness. The complainant in their request letter specifically asks under Section 6254C. I don't know that actually is correct, because that basically is stating items that would not be disclosed. And it's asking for this matrix on all discipline as a result of drive cam. Reading the letter now 3 times more than I've read it twice before, I'm not seeing any specificity as to a request of a breakdown for the whatever it is, whether it's gender or ethnicity or what have you, and that what was provided seems to meet what was asked for. Now the question is what is it? Was it delivered in time? I mean, the request was made on the March 16th, and the response came May 6th with an apology. I think that's excessive. So at bare minimum, there would be a violation of timeliness. Now, I'll hold my motion for that to hear if there are any other members that have additional items they want to possibly add to that. You can include the timeliness. Doesn't seem like there is any. Okay. So then I move to find in violation of, I think it's 6725.
I don't believe so. I don't believe this was an IDR. I think it would be 67.21B.
21B, right. I'm sorry. Right. Yes, 21B.
Have you
Moved.
made it? Did you make it yet?
Yes.
Okay,
Moved.
so I'll second it.
It's already been seconded. Further discussion? The chair will ask, is there any more public comment from anybody who has not already commented? Seeing none, public comment is closed. Roll call, please.
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Cawthon? Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan? Chan, aye. Member Johnson? Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 8 ayes. The motion passes.
Thank you. This matter is referred to Education, Outreach, and Training. Chair will declare a 5-minute recess.
make out individual letters. It's hard to read.
We are back in session. The chair will note that in the matter of items 5 and 6, Dumont versus Rec and Park Department, the complainant and the respondent are still both absent, so this matter remains tabled or postponed. Mr. Clerk, could you call the next item, please?
The next item is the approval of the January 4th, 2011 special meeting minutes.
Is there a motion? Okay, been moved by Member Cawthon. Is there a second? Seconded by Member Chan. Member Wolf.
Yeah, I mean, it's hard to say on these particular minutes whether our concerns regarding the format and how much information is being included for public comment is being adhered to. I mean, I can only see in one case, I think, there's no public comment in any case except in case number 5. And it only just notates Mr. Piccarello and Mr. Hartz, and actually there's a typo there. It should be Ray Hartz, not Rye Hartz. Spoke in favor, and there's no additional summary. I really would like to. I don't believe they got up and just said, I support this. Please vote. I don't believe any of them are that short of words. So, I'm not comfortable with approving these minutes.
Further discussion? Well, a couple of things. First of all, the question, I think, is whether the minutes comply with 67.16. And in 67.16, the only requirement is it says, it says a list of those members of the public who spoke on each matter, if the speaker identified themselves, whether such speakers supported or opposed the matter, a brief summary of each person's statements during the public comment period for each agenda item. So even for action minutes, what we have here may actually fall short under 67.16. 67.16 does not make any reference to general public comment, that is public comment on items not on the agenda. However, I think the task force has consented in the past that we would like to see at least a brief summary of what speakers say during general public comment. There can be exceptions, of course. There was a woman who was coming before us maybe 2 or 3 years ago. She obviously had some mental and or medical problems, and she would mumble into the microphone for 2 or 3 minutes, and her comments were, for the most part, unintelligible. And the minutes reflected that, and it's unfortunate. But most of the speakers we get here, 99 and 44/100%, they come here with a purpose, and they state that purpose very clearly. And, a 1 or 2 sentence summation of what each speaker says, I don't think is asking too much, even when we're talking about action minutes as opposed to detailed minutes. The motion before us is to approve the minutes of January 4th. Is there further discussion? Is there public comment on the minutes of January 4th? Seeing none, roll call, please.
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Cawthon? Aye. Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Costa?
No.
Costa, no. Member Wolf?
No.
Wolf, no. Member Chan? No. Chan, no. Member Johnson?
No.
Johnson, no. Member Nee?
No.
Nee, Mr. Snyder, 3 ayes and 5 noes.
All right. These minutes then are continued until our next regular meeting, January 28th.
Could I just say something?
Member
Why don't
Cawthon?
I would say that the members who have objections to the minutes should tell Mr. Rustum what they want him to change. For
did.
example, under the public comment
I did, Member Cawthon.
Okay, so does he know? You know what they want you to do.
We've had long discussions about this.
No, I mean here, so that we just.
We've had long. He was a respondent to the issue.
No, I'm talking about the January 4th minutes.
I just said that. I said on number 5, it's on page
I got it.
142.
Public
It says
comment.
near the bottom, public comment, Thomas Piccirillo and Ray Hartz, and I corrected his name. It's supposed to be Ray, not Rye. Spoke in favor, period. There should be something more to that. That those two particular people we know have more to say than just, I'm supportive of this. Or
No,
not.
I agree with you. The point I'm making is that if we want the minutes changed, and if we want them in the future to reflect to be done, be provided the way we want them, I think we should be very clear on what changes we need, so that next time when they come back, we can pass them.
Well, that's one of the reasons why we didn't approve them in the first place, and have not been approving them.
Mr. Clerk, could you read the next item, please?
The next item is the approval of the January 2011 special meeting minutes.
Is there a motion to approve?
I move we approve the January 20th minutes.
Is there a second?
Second.
Moved and seconded. Discussion.
I make the same comments.
Further discussion. I have a number of corrections here. In item number 4, public comment, Mr. Hartz is listed as a pro-motion speaker when he was the complainant. Item number 8, Mr. Hartz says Mr. Hartz provided an overview of his complaint. Peter Witt was the complainant. And item 15, again, I have a problem with the description or lack of specificity in the description of general public comment. Further discussion. Is there any public comment on the January 20th, 2011 minutes? Seeing none, roll call. I'm sorry, Member Costa.
Sorry, did you mention item 14, the public comment? And if not,
No, I did not.
Is that acceptable in terms of its level of generality? I just want to make sure that we're hitting all the points if we're going back to fix it.
Okay.
It seems like that was sort of the same principle that we were invoking when saying that the last minutes were not sufficiently complete.
Mr. Rustum?
Mm-hmm.
Oh, okay. Further discussion. Roll call, please.
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Cawthon?
Aye.
Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Costa?
No.
Costa, no. Member Wolf?
No.
Wolf, no. Member Chan? Chan, no. Member Johnson?
No.
Johnson, no. Member Nee?
No.
Nee, no. Mr. Chair. 3 ayes and 5 noes.
Okay, this item is continued until our next regular meeting, June 28th. Mr. Clerk, could you call the next item, please?
Next item is approval of January 25th, 2011 regular meeting minutes.
I move we approve the January 25th minutes.
Is there a second?
Second.
Moved and seconded. Discussion. Okay, I'm sorry, Member Johnson?
These are getting a little better because you can kind of get a feeling for what they were, but there are just a couple of places where we have a similar occurrence with public comment on page 157 and the continuation of item 2, public comment, Peter Warfield spoke in favor of the motion, or in item 3, it says public comment, Jason Grant Garza and Ray Hart spoke on various issues. So if we could expand it just a little bit, similar to what you had discussed in the other minutes.
Further discussion? Also, on in item number 2, in the motion paragraph, line 6, Jewel Gomez's first name is misspelled. I believe it's Jewelle. Is there public comment on the minutes of January 25th, 2011? Seeing none, public comment is closed. Further discussion? Roll call, please.
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Cawthon?
Aye.
Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Costa?
Nope.
Costa, no. Member Wolf?
No.
Wolf, no. Member Chan? Chan, no. Member Johnson?
No.
Johnson, no. Member Nee?
No.
Nee, no. Mr. Chair, 3 ayes and 5 noes.
Can I make a comment? In line with the reasoning that members who voted no have provided, number 5, there's also a public comment there. So we'd love to pass these next time. So.
Okay, this matter is continued to our next regular meeting, June 28th. Mr. Clerk, would you call the next item, please?
The next item is approval of February 17, 2011 special meeting minutes.
I move we.
No.
Okay, no, I'm sorry.
So
Item numbers 20 and 27 are automatically continued because there was no attachment to either one.
21?
We do.
20 and 27.
Oh, okay.
That's correct, but they were not in the information packet, either printed or electronic. Mr. Clerk, could you call item 21, please?
Item 21 is approval of February 22nd, 2011 regular meeting minutes.
Is it?
We approve the February 22nd minutes.
Is there a second?
Second. Second.
Thank you. Is there discussion? Okay, I have a few little things here. Item number 11 in the motion paragraph, I'm not sure about the first name of Ms. Cohen. It's Martha. I believe there's an R in there, but that's something we need to check on. In item 19, second paragraph, line 2, Matos has 2 T's. And in item number 25, this is more substantive. I think there is a misdescription of section 67.21I. It is not a violation for city employees or officials to seek advice regarding sunshine. In this case, it would either have involved wrong advice to withhold disclosable information and or failing to disclose what the city attorney's advice was, I would have to go back and check my notes or listen to the recording. But it seems to me that the item says. Bear with me. Okay, item 25. Motion to find the city attorney's office in violation of Sunshine Ordinance Section 67.21I for providing the Arts Commission with legal advice concerning the sunshine matters. That is not against the ordinance. So that has to be redrafted, and that's substantive, which is reason not to approve.
I'm sorry, repeat your rationale again.
Well, in item number 25,
Yeah.
page 171 of our packet.
6721I. I got that.
Motion to find the city attorney's office in violation of Sunshine Ordinance Section 67.21I for providing the Arts Commission with legal advice concerning sunshine matters. It is permissible for the city attorney to do that. What it is not permissible for the city attorney to do is to appear before this task force and defend a withholding of public information. It is also not permissible for the city attorney or a client to keep confidential advice dealing with sunshine matters. For the city attorney to give advice on sunshine matters, that's perfectly permissible.
What was the motion that was made?
Well, that's what we have to determine. We have to go back and check our own records or listen to a recording, because my suspicion is that this is not an accurate reflection of what the motion was. This needs to be revisited, and if this is an accurate reflection, then, fine. But my suspicion is it isn't. That it's not an accurate reflection.
So, are you saying that the city attorney is allowed to act as legal counsel?
If somebody goes and asks the city attorney a question about sunshine, yes.
Well, but 6721I says that the city attorney's office shall not act as legal counsel for any city employee or any person having custody of any public record for the purposes of denying access to the public.
For the purpose of denying access to the public.
Right, but that their opinions, it may publish legal opinions in response to a request, but that information must be public.
That's right.
Right, and so I think we found that the information that was provided to them was not public.
Member Coughlin, did you have a comment?
Yeah, I just wanted to say that, before Prop G, members of the city attorney's office would come to the task force and defend a department. But I think it's okay for a city attorney to talk to a department head or a commission chair and give them their read on it or tell them what the good government guide says.
The question here, it's a simple question. Do these minutes accurately reflect the motion?
Right.
That is all we're trying to answer here. And because of what 6721I says, I am not sure that this particular description of the motion is accurate. And I think it needs to be revisited. Again, also, in item number 31, general public comment, I think we're in consensus here that is Jason Grant Garza, Alan Grossman, and Charles Pitts spoke on various topics. We'd like to see something more specific. Further discussion. Is there public comment on this item? Seeing none, public comment is closed. Roll call, please.
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Cawthon?
Aye.
Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Costa?
No.
Costa, no. Member Wolf?
No.
Wolf, no. Member Chan? No. Chan, no. Member Johnson? No. Johnson, no. Member Nee?
No.
No. Mr. Chair, there are 3 ayes and 5 noes.
This item is continued to June 28th. Member Cawthon.
I just wanted to make a comment. I know what the Board of Supervisors does with minutes is they say they will submit their comments. So I'm thinking maybe to save time at meetings, we could submit our comments, and the administrator could make the corrections before the meeting.
Member Johnson.
The clerk, Mr. Rustam's supervisors are refusing to permit some of the changes we're asking for.
What do you mean? Through the chair, what do you mean?
We had asked for more detail through the chair. We had asked for more detail, and Member Chair Nee is supposed to have a meeting. Did you have a meeting with her yet?
Haven't had a chance.
Okay.
I'm trying to. I wanted to see if Member Wolf or Member Washburn could join me, and so far neither of them has been able to fit it into their schedule. So we've had to put it off. Mr. Rustin? Oh, okay.
Yeah, we were trying to keep Mr. Rustin from being stuck in the middle because they wanted action minutes, and some of the things they said were taking up too much of his time, some of our changes.
Mr. Clerk, could you read the next item, please?
The next item is the approval of the March 17, 2011 special meeting minutes.
Is there a motion to approve?
Approve the minutes, March 17th.
Is there a second?
I second the motion.
Moved and seconded. Discussion. Is there public comment on this item? Seeing none, public comment is closed. Roll call, please.
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Cawthon?
Aye.
Cawthon, aye. Member Manny? Manny, aye. Member Costa?
No.
Costa, no. Member Wolf?
No.
Wolf, no. Member Chan? Chan, no. Member Johnson? Aye. Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, there are 5 ayes and 3 noes.
The motion passes. The chair at this point feels it a good idea to issue a reminder that under bylaws change recently adopted, a simple majority of those present passes a motion, even if it's substantive. So this motion passes. Mr. Clerk, could you read the next item, please?
The next item is the approval of March 22nd, 2011 regular meeting minutes.
I move we accept the minutes of March 22nd.
Moved and seconded. Discussion. I have a number of things here. In item numbers 1 and 8, I don't think the public comment lines are adequate. In item 7, after paragraph 1, there is a notation 0:0:14. I'm not sure what that means, particularly if that's supposed to mean what time it started. I would guess that it's inaccurate, and also there is no other start time listed for other items. In item 11, in the final line of that item, I believe refilled should be refiled. And item number 27, general public comment, same concern as expressed before by several of us. Further discussion? Member Cawthon?
Let's see. Number 8, third line, starting with heard. It's Ray Hartz.
Further discussion? Member Costa?
Just staying consistent in item number 7, public comment.
Okay. Further discussion? Is there any public comment on this item? Is it?
Excuse me if I missed it, but I think item number 1 just says public comment, Ray Hartz and Thomas Pecorillo, ... So I guess I could have said almost anything.
Refresh our memories, would you please? You said it, not us. Further discussion? Roll call, please.
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Cawthon?
Aye.
Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Costa?
No.
Costa, no. Member Wolf?
No.
Wolf, no. Member Chan? No. Chan, no. Member Johnson?
No.
Johnson, no. Member Nee?
No.
Nee, no. Chair, the 3 ayes and 5 noes.
Okay, this item is continued to the next regular meeting, June 28th. Mr. Clerk, could you call the next item, please?
The next item is the approval of the April 21st, 2011 special meeting minutes.
I move we accept the April 21st minutes.
Is there a second?
Second.
Moved and seconded. Discussion. Is there public comment on this item? Seeing none, public comment is closed. Roll call, please.
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Cawthon?
Aye.
Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
No.
Wolf, no. Member Chan? Aye. Chan, aye. Member Johnson?
Yes.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, there's 7 ayes and 1 nose.
Thank you. Could you call the next item, please?
The next item is approval of April 26, 2011 meeting minutes.
Move we accept the April 26th minutes.
Second.
Moved and seconded. Discussion. I have a few things. In item number 10, public comment order is misspelled. In item number 15, where are we? I believe that the lead paragraph actually misdescribes the item. Let me find that. Oh, yeah, it does. Hearing on complaint filed by Andrew Cisneros against the Larry Littlejohn against the SF Municipal Transportation Agency. So some words need to be... I believe the complainant in that was Andrew Cisneros. So against the Larry Littlejohn should be deleted. Item number 44 lists a start time of 1 hour, 26 minutes, 30 seconds, and I kind of doubt that is accurate, either as an hour or as a time elapsed since the start of the meeting. So I think that probably needs revisiting. Further, Mr. Rustin.
Mr. Chair, if those are just errors, I can just correct it, and if you want to pass it.
Further discussion, Member Johnson.
On item, I'm not sure if this is a typo or not, but on page 195 of our packet and the discussion of item 1 under the second public comment, it says David Pilpel said the power of this paragraph is mainly to push the member to participate or resign. Is it the point? Or purpose or something? It's just a typo. It just sounds odd.
Where-
It sounds like we're trying to force.
Where on the page is that?
Oh,
it said the power of this paragraph is mainly to push the member. Oh,
It might. It seems like he might have said. I could be wrong, but it seems like it might have said point or purpose as opposed to power. And 195.
okay, perhaps.
I mean, it kind of is in context.
I'm sorry?
It is in context.
It is.
Does that sound like something David Pilpel would say to us?
Well, but it's supposed to be a summary. It's not exact quotes. The question is does the summary describe the context of his?
I mean, I could be wrong. You could be right. It just seemed. Go ahead.
But I mean, power of the paragraph doesn't make any sense. We weren't talking about paragraphs. So I would say it should be either point or purpose.
Oh, okay. Semantics. Either way.
Okay. With the correction then, is there further discussion? Is there public comment on this item? Seeing none, public comment is closed. Roll call, please.
On the motion,
Excuse me? Correct, with the corrections. Roll call, please.
on the motion, Member Snyder?
Aye.
Snyder, aye. Member Cawthon?
Aye.
Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Pass.
Wolf, pass. Member Chan? Chan, aye. Member Johnson? Johnson, aye. Member Wolf?
I'll say aye on this one.
Wolf, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 8 ayes.
Thank you. Could you read the next item, please?
The next item is the approval of May 5th, 2011 special meeting minutes.
I move we accept the May 5th minutes.
Second.
Moved and seconded. Discussion? Is there public comment on this item?
I just wanted to say the last 3 or 4 sets of minutes, the one-sentence explanations, I think, I don't see the Board of Supervisors really having a heartache over one sentence. And those are very different than what we were seeing earlier in the evening, which was basically nothing or just listing the names of the people. So I don't think that if you stick with these one sentences and they're reflective, I don't think the Board of Supervisors or the clerk of the board can give you all that much trouble on it. But the other ones are, simply statement of the fact somebody spoke.
Thank you. The chair will note that there is nobody else in the audience section. Further discussion?
Found something.
Member
Number
Cawthon?
1 in the margin. It says start. I guess starts at 005. Is that the way you're keeping time? You're keeping track?
Through the chair, yes, Member Cawthon.
If that's the case, I guess it belongs there. Sorry.
Further discussion? Roll call, please.
On the motion, Member Snyder? Aye. Snyder, aye. Member Cawthon? Aye. Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Costa?
Pass.
Costa, pass. Member Wolf?
No.
Wolf, no. Member Chan? Aye. Chan, aye. Member Johnson?
No.
Johnson, no. Member Costa?
No.
Costa, no. Mr. Chair, we have 4 ayes and 3 noes.
5 ayes and 3 noes.
I'm sorry, 5 ayes.
I vote aye. Mr. Clerk,
Item number 27
Item
is the approval of May 18, 2011 special meeting minutes.
continued to June 28th because those minutes were not in the packet.
Item 28 is approval of March 10, 2011 Rules Committee meeting minutes.
Yeah, I'm wondering why the task force is being asked to approve a committee minutes.
Mr. Chair, when David Pilpel was the Rules Committee chairman, he made a proposal, and it was endorsed by the committee, that if it was 6 months after a meeting had been held and there wasn't a follow-up meeting of the Rules Committee, it had to be approved by the task force.
I've never known of such a thing, and I've not seen any document that has shown that the task force or Rules Committee has ever.
Well, wait a minute. Repeat what you said. If the meeting, I'm sorry.
If the Rules Committee did not meet 6 months from the last meeting, that committee meeting's minutes were to be approved by the task force.
Okay.
Under what reason? Or what's the rationale for that?
I believe it was since the Rules Committee met only once a year, or sometimes several years went by, the minutes were not approved on a timely manner.
Okay, gotcha. So, in other words, the Rules Committee might not meet again for some time, and so, okay. Is there a motion to approve the...
I move we approve the Rules Committee March 10th.
Well, I disagree with that.
Well, is there a second?
Second.
Moved and seconded. Discussion.
As the Rules Chair, I completely disagree with that. How do you know we're not going to have a meeting in the next 6 months? How can you predetermine that? That's ridiculous. And I don't agree without seeing some document that says that this task force has passed some rule like that. It's incredulous. I'm sorry. To me, it's hearsay that rule exists.
Would somebody like to move for a continuance? Member Chan?
Microphone,
please.
Do you know when that happened? When David Pilpel ruled that?
I do not know the exact date, but I'll have to go back and look at the minutes.
Well, he was chair of the task force before I was on it, so it would have been early this decade.
It wasn't the task force, Mr. Chair. It was the Rules Committee.
Oh, okay.
But, Mr. Chair, I was on the task force when he was on the task force. When he was chair of the Rules Committee, I don't remember any such rule ever.
Okay.
I'm like, show me a document that says that.
Perhaps a motion to continue then would be in order.
So moved.
Second.
Okay. Moved and seconded. Is there discussion on continuance? Is there public discussion on the motion to continue?
Actually, just one thing here where it says adjournment, there being no further business, the complaint committee adjourned. This is the Rules Committee.
Okay. Further discussion? Seeing none on the motion to continue?
On the motion to continue, Member Snyder? No. Snyder, no. Member Cawthon? No. Cawthon, no. Member Manny?
Aye.
Manny, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan?
Aye.
Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 6 ayes and 2 noes.
Okay, this item is continued until our next regular meeting, June 28th.
Item 29 is the report from the Complaint Committee meeting of May 10, 2011.
Okay, members Kneber and Washburn are not here, so what you see in the minutes is an accurate reflection of that meeting. Any discussion? Is there public discussion on this item? Public comment? Seeing none, public comment is closed. Next item, please.
Item 30 is report from the Compliance and Amendments Committee meeting of May 10, 2011.
Okay, again, Member Washburn is the chair of that committee. She is absent. Other members of the Compliance Amendments Committee, any comments?
Nope.
Microphone, please.
Microphone, please. Member Johnson?
We approved the Ethics Commission regulations. That was something to report on. And and Mr. Grossman has sent us his edited version in his memo. And that's where this is from.
That's correct.
So that was a big thing out of the way.
And we have yet to set up a joint meeting between the Ethics Commission and the Compliance Amendments Committee. Hopefully within the next month or two. Member Johnson.
Dude, what am I trying to ask? Are these approved, these minutes?
No, these are draft minutes.
We would approve them later.
The committee will approve them.
Because there was some, under that Ethics Commission section, there was some of the members had made comments about how appreciative they were of the work that Ellen Grossman and Member Snyder had done. And I thought that it would be nice to reflect that in these. But this is not the time, I'm sorry.
No, that's fine. Again, these are draft minutes to be approved by the Compliance Amendments Committee. Further discussion. Is there any public comment on this item? Seeing none, public comment is closed. Next item, please.
Next item is the administrator's report. I have one more complaint.
Excuse me, Education, Outreach, and Training Committee?
Yes, that's correct.
So we heard from Mr. Hartz about his complaint against the Library Commission, particularly with regards to our order of determination and a potential sort of inconsistency therein. We found them in violation for not having included a written public statement of 150 words or less in the body of the minutes. However, somewhere in sort of the language of the order, we appeal to kind of the fact that we had not necessarily ruled that way in the past. And Mr. Hertz was bringing to our attention the fact that the Library Commission is still writing their minutes that way, not including public comment of 150 words or less in the body of the minutes. And to justify that, they're appealing to that language in the order of determination, and as well as their advice that they've received from the city attorney. And so we recommended. I'm not sure what the action item is, but I don't. It seems like maybe we need to clarify somehow what the.
Member Coughlin?
At the Library Commission, the chair of the commission said that they were going to listen to what the city attorney said to them, which is that they put the minutes at the end in the appendix. And one of the new members, who's related to Supreme Court Justice, said he thought we should listen to what the task force said. And she said, she snapped. We've already voted on it. And she said the city attorney was going to put his determination in the next good government guide, which thankfully won't. Well, this is from me, which thankfully won't come out for a number of years. Yeah, I just want to comment that the chair of the Library Commission was quite hoity-toity about the Sunshine Task Force, so I'll probably say something in public comment, and I hope it's recorded accurately.
Member Johnson.
The city attorney's going to put an opinion that that it doesn't belong that way?
Yeah.
I mean,
that's what she said.
This is
That's what she said.
Also, through the chair, this is how it's my understanding is that this is how the city attorney is continuing to advise after.
And
Member Bonnick?
Yeah, and I mean, we both, Member Costa and I both asked the representatives from the Library Commission if they were bound to adhere to that advice from the city attorney, and she, they just kept saying that, basically being a little vague and suggesting that that's just what they've been advised, and they want to be consistent with that.
That was
Member
just
Johnson.
the Library Commission people are the ones who told you that the city attorney would be putting it in there.
Yes.
Is that?
She also mentioned it at the Library Commission because, as I say, one of the Justice Breyer's relations said that they should do what the Sunshine Ordinance says. He's a great guy.
Further discussion? Is there any public comment on the complaint committee, on the EOT committee report?
Yeah, I won't get into the matters of the case, but I agree with Member Cawthon's treatment. Unfortunately, they've never actually had a discussion of this item, and more than half of the current Library Commission are new members, and they're just being told, oh, we decided that a long time ago, and that's the way it has to be. And there is some discussion amongst them, and I said, put it on the agenda. Ask the city attorney for a written opinion. And they keep saying, well, we asked him for one, but we haven't gotten it yet. But I'll be honest with you, even if you find that in the minutes is the way to go, I think they're going to ignore you and continue to append them anyway, because Ms. Gomez really has no she made the comment at one of the meetings that the Sunshine Task Force isn't the one who decides what the law is.
Member Cawthon.
I wanted to say a group I belong to made an immediate disclosure request for any opinion of the city attorney on this issue.
Okay. One other thing. If the city attorney does not come forth with any kind of advice or any kind of an opinion, there is nothing to stop members of the commission or members of the public from consulting on sunshine matters with organizations such as Californians Aware, the First Amendment Coalition, the First Amendment Project. And they are very often very happy to, particularly if you have a specific question, they're very happy to provide some thoughts. Next item, please.
The next item is the administrator's report. Mr. Chair, I have one more complaint coming in that will be filed tomorrow.
Okay.
So we have a total of 7 for next month.
7, okay. Any questions on the administrator's report? Is there any public comment on the administrator's report? Seeing none, public comment is closed. Next item, please.
Last item is announcements, comments, questions, and future agenda items.
Task force members. Member Johnson.
I don't know how interested people are in this, but I had mentioned a couple of times about the FPPC posting their investigative files online, and Jerry Brown appointed a new chair, and that chair has said they're no longer subject to the California Public Records Act and has removed all the investigative files online. So, and that happened sometime around the beginning of May, which I was unaware that that was going on. So if I don't know if individual members are interested in writing to Jerry Brown and saying what kind of hoo-ha is that, or if the task force is interested, but just as point of information, that's out there. It just happened.
Member Wolf.
Actually, we should be writing the Attorney General Harris about it.
Oh.
It's a legal matter. Let her. Let's see if she'll take it on. Here's an official disobedience of a state commission. It's not even a department; it's a commission. Well, I guess it is a department, but wow, that's amazing.
Anything further, Member Chan?
I'm just wondering if everybody got the email of submitting the amendments for the November ballot something. I think it's June. Just a FYI to my colleagues that if we want to make it this year, we got to do it ASAP. Or again, we're going to be
yes,
in the next.
I've received it, and I very much appreciate your doing the research on that. So I have made one overture to Supervisor Avalos and have not heard back. I am to be working on this with Member Wolf and Member Washburn, and so we have to figure out among us who else is going to approach whom else on which other supervisors. That's something we have to decide. Anybody, of course, who wants to make a suggestion on whom we should approach, you're welcome to do so. Member Coughlin.
I would say Mercury, and I think I'm going to see him at a fundraiser next Sunday, so maybe if I have a chance, I'll mention it to him.
Fine.
Yeah,
I know.
Office.
Avalos is running too.
And of course, Mercury, I'll be seeing him tomorrow.
Yeah?
So I'll mention.
I can do Avalos. And
I've already popped him an email.
You did?
No response yet.
All right. Well, I can contact him. Pretty close to him. And Yee. Oh no, Yee's a supervisor, not a supervisor.
He's a state senator.
I can do Mar. I can do Kim.
Campos.
I
He's
can
a
do
very
Campos.
good. Yeah, I don't know. I'm sort of concerned about Kim.
I could do Chu.
I'm concerned about
Which
Chu.
one?
Both.
CHIU.
I could do both. You have to understand with the recent activities I've done around canines, we got 10 supervisors. So now I can get pretty good access to all of them, except for even Sean Ellsburn will give me a meeting.
Pretty good about that. Maybe not in this complaint, but he totally came down in the Rules Committee and told them they were violating the Sunshine Ordinance, and he went all out. Jane Kim then said, "Oh, there's we have to go into closed session," and Sean's like, "To make it very clear, it's not closed session about what we just talked about. This is a whole new topic." So he was kind of feeling it out because it's his way of asserting what the lefties kind of assert at them.
Right.
So who knows?
Well, we'll just have to figure some key points that appeal to him. Let him peel out the rest.
Anything else for the good of the order? Motion to adjourn?
So moved.